Welcome to Crime in Court. This is the 1996 Menendez brothers retrial. We are reading through the transcript of their retrial, first trial that happened in 1993 for the homicide of their parents, Jose and Kitty. That took the 1993 trial ended in a mistrial, so we're on trial number two. This is 1996. We have many of the same witnesses, but some different witnesses as well. The state kind of is taking a little bit different of an approach, and they are trying to basically handicap the defense from talking about the essay and the CA that the brothers endured as children. And because in the first trial, they didn't have that information, so the prosecution, well, they had it, but they weren't prepared to really understand the defense's defense on it. So they had the information, they just didn't know what to do with it. So it was kind of a surprise to them, like, oh, this is all new to us. Like that's how they were acting, but they had the information, they just didn't know what to do with it. Um, and they weren't prepared to prosecute a trial defending that, defending their self-defense with the um, SA. So this time around, second time around, I think it sucks for the defense because the prosecution gets to see what the defense has had for their strategy and pick it apart the second time around. So that's kind of what's happening here, and we're kind of seeing that play out. So let's just get right into it. I last time we left off with whatchamacallit. So it was a hearing. The entire episode was just a hearing outside the presence of the jury, and Detective Zoller was called, and Amir Eslaminia was called for his second day of a proffer outside the presence of the jury, and the judge has yet to make decisions on that. He said he was going to come back in the morning, so he might have something to say about that. There may be some arguments at some point during this day. We're going to actually read through. This is a shorter day, so we're actually going to read through the entire day. So that's why you see on the thumbnail a lot of names. And these particular witnesses will go by fast. So it's Larry Cohen. Actually, before I do that, let me shrink myself first and show you. Oh, I didn't have it up. Um, I'll bring up I've had to restart my computer because my audio wasn't working. So I was ready to record like 10 times and then I had to reset. All right, so I'm going to pull up our handy dandy witness testimony list. And this is going to tell us the order in which people testify. So we are now on week 3, and we've gone through. So the last one before that hearing was Donovan Goodrow and Richard Wenskowski. Donovan Goodrow, former friend of Lyle, they used his ID to buy the shotguns. Richard Wenskowski was a bodyguard for Lyle. He testified only for Lyle and said that he heard Lyle talking to his family about something over the phone. So, and he wasn't really a credible witness at all. So today's episode, we are going to go through the entire day of October 26th. Actually, do this. So up first, we're going to have Lawrence Cohen. He's a realtor. Then we have Vicky Rivas, who is the Chrysler slash Jeep saleswoman. And then we have Mark Slotkin, who lent Erik money at Lake Tahoe. We have Wesley Grose, who's the handwriting expert. Remember, Amir Eslamania was talking about this letter that they were writing each other. Supposedly it's from Lyle to conspire to make up some story. But the handwriting, the brothers say, is not there. So there's going to be a handwriting expert. This is new. He did testify for the prosecution. So I'm not sure. So I think I have some of my on my list of people. I think some of the rebuttal people might not be on my list. So when I went searching through here to see who actually did testify previously. I did get a couple wrong. So these people may or may not have testified before. I didn't see them on my list. Wesley Grose for the who's the handwriting expert for the prosecution. He did testify for the prosecution. Michael Guthrie, as far as I know, they did not testify, but we will find out because I'm sure they will ask that question as we go along. All right. So actually, before I switch over to our PDF here of our transcript, I created a backdrop for you guys that's going to have all of the lawyers and Judge Stanley Weisberg and their names are listed, so I don't have to keep saying them. Not that I mind, but you guys might be getting sick of it, especially people who are watching this frequently. So there you have it, and then you can have in your mind's eye as I'm speaking for them what they actually look like, hopefully. All right, so let's get started. Oh, I forgot to say, Michael Guthrie was the LA County Deputy Sheriff. I forgot to say that. All right, so let's get to it. All right, so this is, in case you're following along in the transcripts, this is October 26th. Like I said, we're going to read this whole thing. All right, so the court says, all right, the defendants are in court with their lawyers. People are here. I understand that Mr. Aslamania is here. Is that right? Mr. Khan says, yes, that's correct. Mr. Aslamania is present. The court says, you're ordered to return tomorrow at 8:30. So he came to court today, and then the judge is like, you got to come back tomorrow. Well, remember he disappeared, so they were trying to find him at the end of the day. He was supposed to wait out in the hall. Like the judge ordered him to wait out in the hall, and then he left for the end of the day. He left at the end of the day, and then they were going to put like restraints on him and everything, and get a subpoena to like bring him in. So Mr. Aslamania says, I apologize for leaving yesterday. I meant no disregard for your order. Court says, okay, be back here tomorrow at 8:30. The body attachment is recalled. Other matters that you wanted to discuss. So the thing to, there was like a waist attachment or whatever that Leslie was like, I want him in a waist shackle or whatever. It wasn't a shackle, but whatever it was called. And I thought that was kind of funny because he left. He was supposed to come back for a potential proffer. So, other matters, sorry, the court continues on saying, other matters that you wanted to discuss? Mr. Levin says, no, Your Honor. Mr. Kessler says, no, Your Honor. Court says, okay. The follow-up on that hearing yesterday in regards to Mrs. Maher, the Rolex saleswoman, attached to the hearing related to it was a motion for mistrial, and that motion is denied. You could imagine that that's what he was going to rule because the trial continues and we know that they get convicted. So Mr. Gessler says, I'm surprised. Ms. Abramson says, shocked, stunned. Mr. Gessler says, is shocked the operative word? Ms. Abramson says, stunned. Mr. Gessler says, thank you, Your Honor. Court says, since the evidence won't be admissible, any potential prejudice that might have arisen from the question asked certainly is obviated by the fact or negated by the fact that the witness will be testifying about the specific item asked in question. Ms. Abramson says, is that statement going to be admissible only as to Lyle Menendez? Court says, well, as we discussed yesterday, there was a request by Mr. Levin to have it there was a request by Mr. Levin to have it limited only to Lyle Menendez, and the people indicated that that was the way that they were offering it. And the court would make such a limited instruction and give it to the jury. Ms. Abramson says, thank you. The court says, are we ready to proceed? Ms. Abramson says, we're ready to proceed, Your Honor. Just so the court understands, I believe that we may need may have time to put Detective Zoller on the stand. There is that one issue, and it looks like we will probably have time this morning if the court wants to entertain it, just so the court understands the scheduling. The court says, "You mean you'll run out of witnesses? Is that what you're saying?" Ms. Nahara says, "That's what I'm saying." Court says, "What I want to do is have testimony for the jury. They've been here since 8:30 and patiently waiting. And I understand that there was a witness who was just discovered by the prosecution or they made a determination to subpoena and that witness was being interviewed by the defense appropriately so. That's why we had a delay. Right now, I'd like to get started here and do as much as we can in front of the jury before we have any other hearings outside the presence, so let's have the jury out." The jury entered, and the following proceedings were held. Court says, "Good morning. Sorry to keep you waiting, but there were some matters that the lawyers had to deal with, all the lawyers, and it took us a little while to get ready. We're now ready to proceed." So, whatever happened was. Did it say what happened? Did I miss it or what? Nope. No, it doesn't say anything in the transcript that there was something going on before they came to court. So I don't know what that was, but it's he says, "We're back." So Lawrence Cohen was called to the stand and sworn in. He spells his name and all that good stuff. Ms. Nahara will be doing the questioning for the state. "Mr. Khan, what do you do for a living?" "I'm a realtor." "And in February of 1990, did the defendant Erik Menendez come to see you?" "Yes, he did." "And is the defendant the person that you know as Erik Menendez seated in this court today?" "Yes." "And could you identify him for the record?" "The gentleman in the yellow pink shirt, sorry." Ms. Abramson says, "Yellow striped shirt?" "I will stipulate that the witness is attempting to identify my client, Your Honor." Court says, "All right." Ms. Nahara, her client, oh, Ms. Abramson said, "My client." Sorry. That was Ms. Abramson who said that. I confused myself, and probably you. The court says, "All right." Ms. Nahara says, "Thank you. Thank you, counsel. Now, sir, in February of 1990, what kind of work did you do?" "I was a realtor." "And where were you working?" "I was working in Marina del Rey." "And did you work for a particular realty company?" "Yes, I worked for Fred Sands Realtors." "And in February of 1990, did someone contact you in relation to Erik Menendez?" "Yes." "And who was that who contacted you?" "Stephen Goldberg." "And what did Mr. Stephen Goldberg want?" "He had suggested that he had a couple of brothers who would be interested in buying property in the marina." "And sometime after this conversation, did you meet the defendant, Erik Menendez?" "Yes, I did." And did how long after you had this conversation with Mr. Goldberg did you meet the defendant, Erik Menendez?" "Approximately a week, would be my recollection." "And how did you meet him?" "He came to my office." "And would this be a Fred Sands Realty in Marina del Rey?" "Yes, it would." "I'm going to ask you to speak into the microphone so everybody can hear you." "Okay, thank you." "And when the defendant, Erik Menendez, came into the office, did you have a conversation with him?" "Yes, we spoke briefly." "And what did you speak about?" "We talked about about his interest in finding a home primarily." "And what did he tell you concerning his interest in buying a home?" "He wanted to purchase a home in the area of the marina called the Silver Strand." "I'm sorry, I didn't catch that." "The Silver Strand." "And what is the Silver Strand area, if you could describe that?" "It's an area of upscale single-family residences, approximately 500 yards from the ocean, and there is a canal running through it, a water canal." "You said 500 something from the ocean?" "About 500 yards from the ocean, approximately, maybe a bit less." "And is that one of the nicest areas of Marina del Rey?" Objection calls for speculation and irrelevant. Overruled. You may answer the question. The witness says, yes, it is. And did Erik Menendez tell you anything else during the conversation? Not really anything that I recall other than talking about homes and what he was looking for. And what did he tell you he was looking for? Looking for a large home, approximately 4 bedrooms, as I said, on the canal in the marina. Now, after you had this conversation with the defendant, what did you do? We arranged to see some homes. And where did you arrange? Did you arrange to see the homes that day or some other day? It was a couple days later, as I recall. So, a couple of days later, did the defendant, Erik Menendez, return to your office or did you meet somewhere? He returned to my office. And after he returned to your office, what happened? He then went to the marina strand to look at the homes that I set up for viewing. And how many homes did you set up for the defendant to view? There were approximately a half a dozen. And what happened after you took him out, or did you take him out to those homes? Yes, I did. And what happened when you got out to those homes? Well, we looked at them. He walked through them. He showed some interest in them, and as a normal buyer would, he liked some and didn't like others. Did he appear to like more than the others? Yes, he did. Your Honor, I have a photograph. That's what kind of question is that? Oh, did he? Sorry, I read it wrong. That's not a bad question. Did he appear to like one more than the others? Yes, he did. So that was, he wanted the penthouse, I believe. Ms. Nahara says, Your Honor, I have a photo which I would like marked people's next in order, which I better check my list. The court says Exhibit 135. Ms. Nahara says 135. A photo of what appears to be a home. And I've shown it to the defense. Showing you what's been marked Exhibit 135. Will you take a look at that? The witness does. And now you can tell the jury, or now can you tell the jury what's depicted in this photograph? It's a 3-level home, new construction, Mediterranean or Spanish in style. Now, the home that Lyle Menendez was interested in, the court says, who? Excuse me, I'm sorry. The home that Erik Menendez was interested in, calling your attention to that photograph, does that appear to depict the home that he was interested in? Yes, it does. And the homes that he was interested in, could you describe that? 4-bedroom, 3-level. My recollection is somewhere between 3,200 and 3,800 square feet, brand new on the canal, as was requested. Now, when you say on the canal, this photograph depicts the front of the house and then there's a walkway. Is there something in front of the walkway? In front of the walkway is that water canal that I was referring to. And did the home that Erik Menendez was interested in, what was the asking price for that home? It was 1.4 million. Now, did you look at all 6 houses the day that Erik Menendez came back to look at houses with you? Yes, I believe we did look at all 6. And when you got through looking at all of the houses, what happened? Erik had decided that this particular house was the one that he liked. So sorry about that. My dogs like to bark. There's some loud engine or something outside, and apparently they didn't like that. So apologies. Let's get back on track. I don't remember where I left off. So he says he looked at all 6. So now, did you look at all 6 houses the day that Erik Menendez came back to look at houses with you? He says, yes, I believe we did. And when you got through looking at all of the houses, what happened? Erik had decided that this particular house was the one that he liked and he was interested in it and to eventually make an offer. When you say this particular house, are you referring to the house that you've just described to the jury? Correct. Did it look substantially similar to the photograph that has been presented? Yes. And did you have a conversation with the defendant about that house? We talked about it, and he just indicated that it was seemed to be the kind of house that he would enjoy living in. Now, after you had this conversation, did you do anything else? I'm sorry, I don't understand what you're asking. Did at any time you discuss negotiations and contracts? We briefly discussed that possibility, yes. And then what happened? We eventually wrote an offer on the property. And when you wrote the offer, was that the same day that you looked at the house or was that another day? It was a couple of days following that. So on the day that you looked at the house and you had a conversation with Eric Menendez, is that all that happened that day? Yes. We saw the house, we talked about the house, Eric was going to think about it and appeared to be serious about the house. Ms. Abramson says, I'm going to object, move to strike as calling for a conclusion. Court says, appeared to be interested in the house. Ms. Abramson says, yes. The court says that portion is stricken as a conclusion of the witness. Ms. Abramson says, admonish the jury. And the court says the jury is admonished to disregard that. Ms. Abramson says, thank you. Court says the rest of the answer will stand. Ms. Nahara says, now, the day that you went to look at the houses, this was the second meeting that you had with the defendant concerning purchasing property? Yes. And after you had a discussion with him about purchasing that particular house, did he tell you he wanted to think about it? Yes. Now, sometime after that, did you see the defendant, Eric Menendez, again? He came in a couple of days later, yes. And was it your third meeting with the defendant concerning buying the home? Was this your third meeting? That is my recollection, yes. And when he returned, was he alone or was he with somebody? He was with somebody. And do you recall the name of this person? I recall the first name only, which was Henry. And what happened after when the defendant came back the third time? Did you have a conversation with him in your office? With the defendant? Yeah, right. Yes, yes. Did you have a conversation with anyone else that day? Did you have a conversation with the person he was with as well? Yes, I did. And did you discuss the purchase of the house that Eric Menendez was interested in? Ms. Abrams says, I'm going to object to that unless it's designating who he's discussing it with. Court says, well, this is just a general question at this point, so the objection overruled. You can answer that. Yes, I did discuss the purchase of my house. Of the house. Ms. Nahara says, and with regards to your interactions with the defendant, Eric Menendez, what happened with regards to facilitating the purchase of the house? Well, he decided that he would like to make an offer, and we went ahead with that. When you say decided, you're referring to Eric Menendez? Yes. And did he say anything to you about wanting to purchase the house? I don't recall in specific words in that light, but by virtue of the fact that he wanted to write an offer, it appeared to me that he was interested in buying a house. Yes. And what did you do with regards to writing an offer? We wrote the offer. And what was this offer? It was a fairly standard offer. The list price was 114 and the offer was 11. Now, for those people who are not knowledgeable about how these things are done, how did you go about presenting or writing an offer? What is involved with that? When you sit down with a client and you write the offer, it's the client's wishes that are portrayed on the offer. Your Honor, I'm going to object to this generalization unless that's precisely what happened here. The court sustains that the answer is stricken. Ms. Nahara says, with regards to specifically Eric Menendez, what did you do with regards to writing this offer? Went through every paragraph of the offer and discussed with him how he wanted to handle each paragraph. And how many pages? First of all, I take it this offer is a written document. Is that correct? Correct. And how many pages was it? At the time, take a shot. Remember from last episode, they said at the time so many times that if you took a shot, you'd be going to the hospital. At that time, I believe it was a 4-page offer. And what did you do? You had this 4-page offer with you. What did you do with regards to the defendant, Erik Menendez? As I stated, we discussed each paragraph, we wrote each paragraph and I, I decided would be the most appropriate way to handle it, signed it, and went on with it. And who had to sign this 4-page offer? Erik Menendez. And did he sign it? Yes. Did he have to initial it in places? Yes. On the bottom, each of the foregoing pages before the last page is required to have the buyer's and seller's initials. And I may have asked this, but can you tell me how much was the offer made in this contract? Ms. Abramson says, asked and answered, Your Honor, overruled. The offer was 1.1 million. I mean, they did answer this already. Ms. Nahara says, and what did you do once all of this paperwork was finished, completed? Wished Erik luck in purchasing the home, and after he left, called to present the offer to the other side. And sometime after this third meeting with Erik Menendez, did you present this offer? Yes, I did. What happened then? It was countered. And what was it countered at? My recollection is it was countered at 1.35. And can you explain to us what countered means? Yes, when the offer was presented, the seller agreed with many of the paragraphs in the offer. However, with regard to the price, they were not willing to accept that price, so they countered back at a price that they felt more comfortable with, and that was the 1.39, 1.35. Sorry. Now, after you received the counter of the 1.35, what was the next step that you do? I attempted to call or to contact Mr. Menendez, Mr. Erik Menendez. And what happened? I was unable to do so. And did you learn later why why it was that you were unable to contact him? Objection, Your Honor, calls for speculation. Sustained. Were you able to ever contact him after? I'm sorry, when was the last time that you had any transactions with Erik Menendez? At the time, take a shot. Ms. Abramson says, I'm going to object to the form of the question, assumes facts not in evidence. Court says, well, it's vague what you mean by transaction. The last time he saw him, spoke with him, or what? Ms. Nahir clarifies. After the third meeting that Erik Menendez, where the offer was worked through and negotiated, did you ever see him again? No, I did not. And do you recall when that third meeting was? Not specifically, other than sometime in, I believe it was February of 1990. And were you unable to contact Erik Menendez in March of 1990? Ms. Abramson says, assumes facts not in evidence, Your Honor, sustained. Did you try to contact the defendant, Erik Menendez, in March of 1990? Yes, I did. And were you able to contact him? No, I was not. And from March of 1990 to the present, were you ever able to contact him? Ms. Abramson says, assumes facts not in evidence, sustained. Did you try to contact him? No, I did not. Why didn't you try to contact him? Objection, Your Honor, irrelevant and calls for hearsay, sustained. Because basically they're trying to say because he got arrested. Like, you can't say that. Ms. Nahara says, after that third meeting, were you ever able to present the counteroffer to the defendant, Erik Menendez? No, I was not. Thank you. Court says cross-examination. So I told you these were a little bit shorter than these witnesses are a little bit shorter. We fly through them a little faster. So Leslie Abramson is the defense for Erik, and she's going to go into cross-examination first. She says, "Good morning, Mr. Cohen. Mr. Cohen, what's the address of that house in the picture?" "I do not know the specific address. It's on Via Dolce." "And were there other houses on Via Dolce that you took Erik to?" "Yes." "What were their addresses?" "I don't know on the specific addresses of those. They were on Via Dolce." Do you know when that photograph was taken? I don't. I did not take that photograph. You didn't take it. And in fact, you weren't even interviewed about Eric Menendez and these meetings with him up until August 26, 1993. Is that correct? So, isn't that when the trial's already taking place? He says, I'm not sure of the time frame. I know that I was subpoenaed for the first trial. So yeah, right around when the first trial was starting, I think. I can't remember when exactly it started, but I know it was like like late summer, early fall. So that would be right around then. I'm not sure of the time frame, he says. I know I was subpoenaed for the first trial. So you were interviewed the first time by Detective Zoller of the Beverly Hills Police Department. Yes. And you don't recall when that was? Not specifically, no. Do you recall whether or not it was after the first trial had begun or in the middle thereof? It was before the first trial. So you were subpoenaed by the prosecution for the first trial. Right. Ms. Nahara says, objection, irrelevant. Why is that irrelevant? And the court agrees that it is relevant, and he overrules that. Ms. Amerson says, you didn't, however, testify, did you, sir? No, I did not. And Mr. Cohen, you have a single piece of paper that reflects, you don't have a single piece of paper that reflects any meetings, any phone calls, any offers, anything with Eric Menendez. Is that correct? That's correct. And is it fair to say that because you have no paperwork, you can't be certain of the address of the property? Yes. And do you remember so how does he not have any paperwork if he wrote up an offer? Wouldn't that offer have a date on it? Like, I'm confused. Why does he have no paperwork? Hmm, maybe I'll get into it. And do you remember the names of the owners of the property? I never knew the names of the owners of the property. This was not your listing? No, it was not. This was another real estate agent that had listed the property, and you had to contact that person to gain access for any potential clients you would be taking to show, right? Correct. And do you know if the property ever sold? I believe it did. Do you know when? No, I do not. Do you know for how much? No, I do not. Now, before you received this, strike that. The first step, if you will, in this incident was a telephone call from an attorney named Stephen Goldberg. He was, I believe, the lawyer that the family hired to execute the will. That's correct. And did you know Mr. Goldberg from before that telephone call? Yes, I did. Was he an attorney who had referred other people to you who were interested in looking at properties? No. He had never referred anyone to you before? Never. And did you tell Detective Zoller on August 20th, 1993, that you had received a call from Stephen Goldberg, an attorney, that you had gotten other referrals from? I did not. So somebody's wires are crossed because did Detective Zoller put that in his notes and he didn't say it, or did he say it and now he's backtracking and saying that he didn't say it? It's questionable. So you never said that to him. How did you know Stephen Goldberg? Steve Goldberg was looking for a property a long time prior to this incident, and I was his agent at that time. Take a shot. At that time. In case you missed the last one or didn't watch it because it was just a hearing, there was no real testimony I mean, there was testimony, but it was outside the presence of the jury. I said we should make a drinking game out of every time that they say at that time because they say it a lot. And sometimes they also say, as I sit here now, which is another one. It's another version of at that time, but it's like in present form. So I don't know. It's just funny. And I keep noticing it because I have to say it every single time. So take a shot. He was looking for a home for himself? Correct. And were you the agent who helped him purchase the home that he, in fact, has now? No. Okay, did he purchase a home? He purchased a home in Torrance, I believe. But he didn't purchase a home through you. No, he did not. And did Mr. Goldberg tell you that he had two brothers who were looking for a home to share? Yes, he did. And that they were looking for a large home so that they could both live in it. I don't remember those exact words, but he did say that they wanted to share a large home. Okay. And that was Erik and Lyle Menendez, correct? Uh-huh, yes. And that they were interested in the marina area. Did he tell you it was because they were already living in the marina area? Yes, he did say that. And at some point, in fact, did Steve Goldberg also tell you that Henry had referred the boys to him, and thereby to you, for the purpose of looking for a home in this area? Eventually, yes. And Henry, did you understand Henry to be a relative of Erik and Lyle Menendez? Objection, no foundation, overruled. Eventually, I found that to be the case, yes. Ms. Abramson says, and did you also find out to be the case that Henry was himself a real estate agent, though he didn't operate in the Marina Del area? Yes. And would you agree, Mr. Cohen, that Henry is a very local person? Objection, no foundation, sustained. Based on your contacts with him, does he talk a lot? Objection, irrelevant, overruled. You can answer the question. Witness says yes. And did he talk a lot during this period when you say you were drafting the purchase order, the purchase offer? Objection, irrelevant, overruled. I don't believe Henry got terribly involved in that. Was he there? He was there. And in fact, he demanded a commission from the sale, did he not? Yes, he did. He demanded a 50, holy crap, a 50% real estate commission originally, didn't he? Originally, yes, that's wild. Wildly, extremely high. And in fact, a deal was worked out with Henry that if this sale went through, he would get 10%, that sounds more like it, of the real estate commission, as opposed to 50%? Yes. Yes. And therefore, as you understood it, this person, Henry, had a financial interest in this sale going through. Yes. Now, it was standard. Well, strike all that. Is a real estate purchase offer a standard form? Most of the large companies have their own forms, but they are based on a standard form, yes. Okay, but your company had its own standard form. That's correct. These 4 pages were not something that you had to type up that day? No. They're pre-printed paragraphs, correct? That's correct. And there's a few things that get written in for each individual offer, correct? I don't know that I would define it as a few, but I guess we could go this way, yes. Well, in some, there's a lot. Some people are very finicky and very specific and have a lot of very specific terms, and other people are more general and don't try to change the form or add things. Is that fair to say? I'd say so, yes. And this form is not just a recitation that A is offering B X amount of dollars for Y property. It also has all the escrow terms built in. Yes, that's true. And those things that the law requires, paragraphs about liabilities and responsibilities and inspections and deposits and timing, all of that. That's correct. And more. Warranties and lack of warranties, right? Yes. There is a thing written originally by lawyers, correct? Unfortunately, yes. Why unfortunately? And it's a very technical document with a lot of very complicated items. Yes. So it's your obligation as a real estate. Are you a broker or a salesperson, sir? I'm a salesperson. As either a broker or a salesperson, you have to show this to potential buyers and make them read it and ask them if they understand it, correct? You have to explain each paragraph to them, yes. By law, you have to read it out by the dictates of the Department of Real Estate. Yes, exactly. And it takes a while to do that. It does take a while. All right. Now, one of the things that had to be personalized, if you will, on any real estate offer is the price, correct? Yes. Another thing is the length of escrow. In other words, how long the buyer is going to have to get their loan and to get everything done that needs to be done, buyer and seller, so that the houses can change ownerships at some point, correct? Yes. And escrow can be anywhere from about 30 days to whatever the people are willing to agree on. That's correct. Do you remember any specifications or any specific terms of this particular offer other than the dollar amount? No, I do not. Now, are you certain, Mr. Cohen, that you saw Erik Menendez on these three occasions as compared to two? No, I'm not 100% positive. And are you aware that you have previously given statements both to the Beverly Hills Police Department and to Miss Cynthia Erdelay, the defense investigator, that there were only two contacts as opposed to three? He says, I don't remember the statement to Ms. Cynthia Erdelay. Erdelay. I do remember speaking to the Beverly Hills Police Department. It is highly conceivable that two was the issue. Yes. Okay. So now he's going back and saying, I don't remember it, but yeah, it could have been. It's highly conceivable. And can you remember now, all these years later, whether or not Henry, by the way, does the last name Lanio sound familiar? It does. All right. Then we'll stay with Henry. Or it does not. I'm sorry. It does not. He says it does not. So he doesn't remember Henry's name. All right. Then we'll stay with just Henry. Okay. Did you recall if Henry ever saw that property in your presence? It's my It's my recollection that Henry did not see that property in my presence. All right. Is it your recollection that the only time that you saw Henry with Erik Menendez was in your office and not when viewing the properties? Is that your memory? That is my memory. If Henry was a contrary memory, can you be sure that his memory is wrong and you're right? Objection, argumentative, overruled. That would be his memory, says the witness. Ms. Abramson continues, are you certain of your memory or has it just been too long to know? I am not certain, and it has been a long time, yes. Thank you. This area, the Silver Strand area in the marina, were you familiar with the progress of its development? Objection, irrelevant, overruled. Its early development when it was just a swamp, you mean? Ms. Abramson says, well, it was a set of oil wells were there at one time, right? It took a long time before anyone got permission to build on it. Objection, irrelevant, overruled. I would think so. I don't know, says the witness. Ms. Abramson says, was there any problem in moving properties in that area because of the previous problems with oil development there? What do you mean by moving? Well, you know, the Love Canal problems. Were people concerned ecologically moving, selling the property? By moving, you mean selling. I don't mean picking up and moving it. There was some concern about that, but the property sold relatively well. So when you said it was one of the best areas in the marina, it was not without its problems. Would that be fair to say? I would agree with that. And at that time, this canal was that what's called the Grand Canal? It's an extension of the Grand Canal, yes. And that's something that was built mainly in the Venice area. It's like, is that the Grand Canal that comes from the Venice area, which was once developed to look like Italy, but didn't quite make it. Now it does look like like Italy again, he says. So these canals require a lot of upkeep. The water goes bad and they smell pretty bad. That does happen. And in fact, at this time in 1989, wasn't the Grand Canal that goes through this area had not yet been renovated. It was having pollution problems. It had not been renovated. I don't know about the pollution issue. And was the condition of the canal another factor in making it, I wouldn't say difficult, but a big factor in being able to sell the properties on the canal? Yes. And for the beachfront area of LA County, would you say that the houses in this area were much lower priced than houses in the Malibu type area, the Santa Monica beach area, those areas? Objection irrelevant as to other areas, and the court overrules that. The witness says the property we're talking about was not a beachfront property. Ms. Abramson says it was near the ocean. It was within 500 yards of the ocean, as I said, yes. And within 500 yards of the ocean, Malibu is a much more expensive area, is it not? I'm not familiar with Malibu. That is not my area. All right. Mr. Cohen, how many other sales didn't you make in 1989 and 1990? I don't know. Okay. This was not such a remarkable event that you didn't complete a sale. No, it happens frequently to many people, not just myself. I wasn't suggesting it was you. People come and they look and even make offers and they don't follow up. Correct. I take it there was no deposit? There was no deposit that I recall. There was a statement that a deposit would be made. But of course, if there's no deposit whatsoever, someone can walk away from this without a second thought. There's no money changing hands. Does happen, yes. Well, is this the case? It could have happened. In this case, it could have happened. There was no money that changed hands, correct? Ms. Nahara says, I'm going to object as to what could have happened as irrelevant. Cortez, perhaps you can rephrase the question. Ms. Abramson says, by walking away, Mr. Menendez did not incur any kind of financial liability. Well, let me back up. First of all, he didn't walk away. The seller didn't accept. That's the point. Money did not exchange hands anyway, because the seller did not accept. That's correct. Isn't it quite customarily when someone is making an offer to a deposit of a certain percentage of the purchase price is required on a good check and that's told to the seller? Customary, but they do deviate from that for a variety of reasons. Desperation being one of them. Sometimes a buyer forgets to bring in a check and they say they'll come in the next day. But that wasn't the kind of arrangement you had with Erik Menendez. He wasn't expected to bring in a check. Do you remember the day of the week that he first came to the day of the week that he looked at the properties? Let's put it that way. No, I do not. Do you know if after Mr. Goldberg called you and told you that Lyle and Erik wanted to buy a home to share, whether at that time you started setting up properties to view? I started researching what Mr. Goldberg told me was within their needs and requirements. Okay. At some point, Mr. Cohen, you learned that Erik and Lyle Menendez had been arrested. Yes. And you certainly didn't make any effort to contact anybody after that happened. You didn't think you were going to sell a property to somebody in jail, did you? But you said anybody. You did talk to Steve Goldberg? Yes, that's correct. Okay, Mr. Cohen, just a general question here about value. Did the real estate market in this area of Los Angeles where this home was crashed the same way it did everywhere else in about 1990 to 91? Yes, it did. I'd object as irrelevant, not pertaining to 1989. Overruled. The witness says yes, it did. Ms. Abramson continues, and was it your impression when you were talking to Eric Menendez that he wasn't seeking to purchase a house for an investment, he was seeking to purchase a home to live in. Yes. Because this wouldn't have been a great investment at the time, would it? I'd object to irrelevant, says Ms. Nahara. At what time, says the court. At the time that we're talking about, February of 1990 is just before the big crash, isn't it? Court says, are you asking from the perspective of now or February of 1990? Ms. Abramson says, yes. From the perspective of now back, that home lost value, didn't it? I'd object as irrelevant, sustained. Ms. Abramson says, okay, just to make sure I understand you. When you're filling out the standard form, you're filling out a word here and a word there in each of these paragraphs, correct? In some of the paragraphs, some of them are boilerplate. Without any requirement for explaining, you don't have to write anything at all? Correct. Others, it's just a few words or a number? Right. So when you say you wrote each paragraph, that's what you meant. Whatever needed to be written in these words in the paragraph that required anything to customize the standardized form. And explain each paragraph, yes. Right, you had to read it. Do you remember what time of day it was on the day that you wrote up the offer? I believe it was early afternoon. Okay, thank you, sir. I have nothing further, Your Honor. The court says, thank you. Any other questions? Mr. Gessler says, no, Your Honor. Ms. Abramson says, excuse me, I'm getting a quizzical look. Perhaps I do. The court says, any redirect? And Ms. Nahara says, yes, Your Honor. Ms. Abramson says, I'm not done yet. I'm having consultations. All defense attorneys confer. Ms. Abramson says, Mr. Cohen, how do you remember that this happened in February? How do I remember? That tense, or that these, sorry, that these contacts with Eric Menendez are in February. How do you know that these contacts with Eric Menendez are in February? Basically, I projected back from the time that I realized that they had been detained. So, and they were approximations. So, all right. So, at some point, you learned that Eric Menendez and Lyle Menendez had been arrested. Yes. Is it your impression that they were arrested on the same day? No, I'm sorry. Would you state that again? Was it your impression they were arrested on the same day? That both Eric and Lyle were arrested the same day? Why is this so difficult to understand? Yeah, I don't know. I have no opinion. So your understanding is that Eric Menendez was out of the country? Yes. At the time that Lyle Menendez was arrested. Ms. Nahara says, I'm going to object. Calls for hearsay, no foundation. Overruled. Your answer? The witness says, I knew Eric was out of the country. I have no recollection of whether Lyle was arrested before, during, or after. Miss Abramson says, okay, you knew he was out of the country and came back and then got arrested. Yes. So you tried to work backwards from when you learned he was both out of the country and arrested because those two events were close together. With respect to the time frame, yes. And then you're just giving your best guess? My best estimate, yes. And do you know how long he was out of the country? My answer to that would only be based on what I've heard recently. So you didn't know it at the time that you were formulating your best estimate because you gave your best estimate in August of 1993. My understanding was he was away for 2 weeks. And when he was arrested, or when did he come back? I don't recall the specific date of that. So how did you get from he was away for 2 weeks to you saw him in February? Well, my presumption was that I saw that he was arrested in March, February, early March, and worked it back from there. So he was arrested in March and had been away. March couldn't have been it. It had to be February. That was basically my thinking, yes. And the fact that you couldn't contact him suggested to you that maybe it's because he had left after the fact. Yeah, you didn't know that he had left when you were first trying to contact him. No, that's correct. Do you have contacts with people who have looked at property, Mr. Cohen, and talked about wanting to write up an offer, but never actually do it? Objection, irrelevant, overruled. The witness says yes. So people who say, well, gee, I like this house, they want 1 million for. I wouldn't want to give more than 1 million, 1 for it. I want to think about it. Maybe I'll make an offer for 1 million, 1. What do you think, Mr. Cohen? Will they go for 1 million, 1? That kind of conversation happens, yes. And do you also have situations where you get as far as writing the offer, but the client still wants to think about whether you should present it? Object to anything that doesn't relate to the case. Overruled. The witness says very rarely. Ms. Abramson says, and how do you, first of all, do you have a clear recollection of presenting this offer? It was, no, I don't. Is it possible you didn't? No, it's not possible I didn't. Because you believe there was a counter. There was a counter. Objection, argumentative. What? How's that? What? Overruled. There was a counter, the witness says. And do you recall who would you have presented an offer to? The developer. So this was still developer owned. It was a brand new home that was developer owned. Now this house is a lot of house on a very little lot. So a lot of house on a small lot. They all are over there, yes. It's all house, this lot. Virtually no yard. Mostly house, yes. So no yard really. There's some side stripping, basically no yard. There's a bit of front yard fronting the canal. No pool? No pool. No tennis court. No tennis court. No room for a ping pong table, in fact. Inside the house, there's plenty of room for a ping pong table, but not outside the house. No. Like you knew what you was asking, buddy. And is this like a condominium development, or are these just individually owned homes? Single family residences. There's no common anything? There are common charges based on the upkeep of the canal. Upkeep of the what? The canal. That's the canal. There's no like common grounds or common facilities or anything like the way a condo community is put together. There was a park further down for children. What does that have to do with anything? I'm getting at something different. I'm talking about common swimming pools, common rec areas, that kind of thing. Not associated with this overall development, no. So there's no common tennis courts even here. Not in that development. There are around there, but not there. Okay, thank you, Mr. Cohen. And the witness says thank you. Any redirect? And we have some redirect. Ms. Nahara asks, Mr. Cohen, if you can clarify something for me here, my question to you is the area, Silver Lake area, that you showed the defendant, Erik Menendez, the home that he was interested in, was that a rundown area? Are you talking about Silver Lake or Silver Strand? Silver Strand, sorry. It's not a rundown area, no. Is it a depressed neighborhood? No. Ms. Abramson says, we're talking now, Your Honor, or in 1989. And the court says, let's clarify that. Ms. Nahara says, let's start with 1989. Was it a rundown area in 1989? No, it was not. Was that a depressed area in 1989? No. Was it a ghetto in 89? No. Was it a swamp in 89? No. What kind of area was this in 1989? Ms. Abramson says, Your Honor, this was asked and answered already on direct. The court says, well, it was covered again on cross, so I'll permit the inquiry. Overruled. The witness says, would you repeat the question? What kind of an area was Silver Strand in 1989? It was a well taken care of, upscale neighborhood. And when we say upscale, what does upscale mean to you? Homes at the time were valued at over $1 million. And all the homes that you showed the defendant, Eric Menendez, when you showed him the 6 homes, were they all $1 million+ homes? Yes. And we're talking $1 million, right? Yes, $1 million. And the homes in this neighborhood, Silver Strand, in 1989, were they all priced approximately in the $1 million range? $1 million and up, yes. And you said this was a development that was still owned by the developer, is that right? It was. The particular home was still owned by the developer. And the Silver Strand homes in 1989, were they selling for $1 million+? Yes, they were. And I believe you were asked whether or not there was a problem selling them. I think the word used was moving them. Was it any more difficult to move them than any other $1 million properties? Every property has its pluses and minuses, and these did have a couple of minuses that were outlined, but they did sell because of the many pluses that were involved as well. And you were asked with regards to comparing them to homes on the beach, whether or not they were typical or not. Now, not comparing them to homes on the beach, but comparing them to homes on these canals some yards from the beach, was this your typical upscale type neighborhood? Ms. Abramson says, I don't know what that means, Your Honor. There are all sorts of upscale neighborhoods. And the court says, sustained. It's vague. Ms. Nehir says, okay. You said this home was not. You weren't sure if this home would be as expensive as homes on other beaches that Ms. Abramson pointed out to you. Is that right? The specific beach that she had pointed out to me, I would not know because that is not in my area. So would you consider this an expensive home on the beach? Court says it wasn't on a beach. Would you consider this an expensive home for this area for a typical employed 18-year-old? Ms. Abramson says, I'm going to object to that. Calls for speculation. What's typical? Court sustains that. Ms. Nahara says, I have nothing further. Court says, all right, anything else? Ms. Abramson says, no, Your Honor. And the court says, okay, thank you, sir. You may step down. You're excused. Your next witness. Ms. Nahara says, thank you, Your Honor. The people call Vicky Rivas. The bailiff says, I believe a juror has a question. The court says, raise your right hand. And they swear Vicky Rivas in. And the court says, let's take a short break. A juror needs to take a little break. Sorry, we'll take a recess of 15 minutes. Ms. Abramson says, thank you, Your Honor. And now everyone is back. We'll have the jury out. The jury entered the courtroom and the following proceedings were held. Judge Weisberg says, okay, the jury is back. We have our witness on the witness stand. She was sworn in just before our recess. Could you say your name again for us, please? And she repeats it, Vicky Rivas. She spells it. Direct examination by Ms. Nahara. Ms. Rivas, in October of 1989, where did you work? At the Burge Chrysler Jeep. And what did you do at the Burge Chrysler Jeep? I'm a salesperson. And a few days prior to October 21st, 1989, did you have an opportunity to meet the defendants in this matter, Lyle and Erik Menendez? Yes. And are those the two individuals that you see in court today? Yes. And do you recall how long before October 21st, 1989 that you first met the defendants? Not exactly. It was a few days before. And how did it come about that you met the defendants? They came in to look at a Wrangler, a Jeep. When you say they came into the store. And did you meet them sometime after they came into, was this a Jeep dealership? Yes. Did you meet them sometime after they came into the Jeep dealership. Yes. And what happened after you met them? What was the first thing that you did with them? We showed them a lot of different Wranglers and they wanted to drive one. Mr. Levin says, Your Honor, I would object to them and they. The court says, if you can specify who it was that you're referring to, if you spoke with one, or if you said something or both of them together, or doing something together or separately, if you can identify that. Ms. Nahara says, after you first met them at the Jeep dealership, did you have a conversation with either or both of them about the Wrangler, what equipment the Wrangler had on it, the engine, and so on? And what I'm asking you, though, is did you have a conversation with one or both of the defendants? Yeah. The court says, was it with both of them together or just one, if you remember? I don't really remember. And Ms. Nahara says, and do you recall having a conversation when the defendants came into the Jeep dealership with them? Mr. Levin says, objection with respect to the question. The court says, sustained. The question is vague. Re-ask it, please. Ms. Nahara says, right. Right after you met the defendants, Lyle and Erik Menendez, did you show them something? Mm-hmm. A Wrangler. And did you specifically show one of them a Wrangler, or did you show them both a Wrangler? Both. Did either of them ask to see this Wrangler before you showed it to them? I don't remember that. I'm there to show a lot of different colors and Wranglers. And what Wranglers did you show them, or did you show them more than one? More than one. Beg your pardon? More than one. We have a pretty good sized lot. And how many Wranglers did you show them that day? I don't really remember. And after you showed them the Wranglers, did you go somewhere with them? On a test drive, uh-huh. Now, who all went on that test drive? Lyle, Erik, and myself. And did you need to see someone's license to go on the test drive? Yes. And whose license did you use to go on the test drive? Erik's license. And do you recall having any conversations with the defendant, Erik Menendez? Just conversation about the Jeep. And what was that conversation? Just the horsepower and just about the Jeep, the horsepower and what sort of engine it had. And did you have this conversation with Erik Menendez about the Jeep before you went on the test drive, during the test drive, or after the test drive? All of those, before, during, and after. And what else besides the horsepower did you discuss concerning the Jeep Wrangler? That it was a convertible if they wanted it to be, or it could be bought with a hard top or a soft top. And do you recall anything else about the conversation with Erik Menendez? Not really. Now, how long did the test drive take? About 10 or 15 minutes. And who drove the Jeep during the test drive? I'm not sure. I really don't recall if one or both Erik and Lyle did. I don't remember. Did you drive the Jeep at all? No. Now, after you were through with the test drive, did you return to the Jeep dealership? Yes. When you returned to the Jeep dealership, did you have a conversation with the defendant, Erik Menendez? Yes, they said they would be back. They would think about it. They wanted a specific color. Now, when you say they, did you talk? I'm sorry. I'm asking specifically about the defendant, Erik Menendez, that you said you had a conversation with. What do you recall him saying? Nothing in particular, other than they would come back. He would come back. And did he tell you anything concerning the Wrangler, whether or not he liked it, whether he was interested in it? Objection, leading, overruled. You can answer the question. The witness says he liked it. Beg your pardon? He liked it. Did the defendants leave the Jeep dealership at that time? Yes. Did you ever see the defendant Erik Menendez again? Yes. And when was that after the first incident? Perhaps a few days later. I'm not exactly sure. And when you saw Eric Menendez, was this the Jeep dealership? At the Jeep dealership? Yes. And was he alone or was he with somebody? With Lyle and another gentleman. And do you recall the name of the other person? No. Now, on that day, did you have a conversation with any of these people? Yes, I was told to deal with that gentleman that was Eric. I was told to deal with that gentleman that was with Eric and Lyle. And who told you that? The person that I don't know who he was or what his name was. I don't remember it. So this gentleman who came in with the defendants? Mm-hmm, yes. Okay, and did you have a conversation with this gentleman? Yes. And where was the defendant, Eric Menendez, when you had this conversation with the gentleman he brought in? They were sitting at my desk at the Jeep office. When you say they, who are you referring to? All three, Eric, Lyle, and this gentleman. And where was Eric Menendez in relation to this gentleman? Was he seated next to him or was he? Yes. And did you proceed to have a conversation with the gentleman about Eric Menendez buying a Jeep? Yes. And what do you recall of that conversation? Eric wanted certain things put on the Jeep to customize it and price. Okay, starting with the first customization, what do you recall? First of all, what is customization? It's custom wheels and tires and seats, bumpers, brush guards, totally as custom steering wheel. So it's customized something that's done to an individual Jeep over and above what comes out of the factory? Yes. Does it cost more? Yes. So it raises the price of the Jeep. Certainly. And do you recall what kind of customization you discussed on the Jeep that Eric Menendez was interested in? Well, I take it to the manager and no, 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 no. What I'm asking you, this woman does not want to answer straight answer a question with a straight answer. She's just all over the place. She might be nervous, but still, she's not listening to the question. She's just all over with her answers. What I'm asking you is what were the customizations that you talked about with this individual concerning the Jeep? What specific customizations? With the wheels and tires, the steering wheel, custom seats, brush guards, side bumpers, and I think that's it. And when you said steering wheel, how did he want the steering wheel customized? It's a special steering wheel that we have a leather it's a special steering wheel that we have that is a leather steering wheel. Ms. Nahara says, and Your Honor, I have a photograph which I've shown to the defense and I would like to have marked as Exhibit 136 for. Ms. Abramson says, we objected. The court says, whose witness is this? Mr. Levin says, mine, Your Honor. We had previously lodged an objection to that photograph. The court says, all permitted to be marked but not shown to the jury. You can show it to the witness. Ms. Nahara says, thank you, Your Honor. And showing you the exhibit that was marked 136, will you take a look at that and tell me if you recognize what's depicted in the photograph? It's not the car, but that's the type of. Yes, it's a Wrangler. Is that a 1989 Jeep Wrangler? Yes. Objection, no foundation, overruled. You can answer that. Yes. And is it the type of Jeep Wrangler that you were negotiating to sell to the defendant Eric Menendez? Yes. And is there something different about the Jeep Wrangler in that photo as compared to the one that you sold to the defendant Eric Menendez? It's a different color. And what was the color of the Jeep that you sold? Sort of a beige sand color. And these special customizations that he asked for, are they depicted on this Jeep? No. And is this the standard model before customization that you see there? Yes. So the picture is just the standard model. So why are we showing a standard model if that's not what he ordered at all or wanted? So now, after you were through discussing customization with the third individual, you testified that you discussed price. What was said about price? What was discussed? Negotiations go back and forth. We arrived at a price. Mr. Levin says, Your Honor, I would object to the conversation as hearsay. Overruled, but any further conversation, please establish who was present. At these negotiations with the third individual, was the defendant Erik Menendez present? Yes. And was he sitting next to the man that you were referring to? Yes. And were you discussing the Jeep Wrangler that Erik Menendez, was interested in buying? Yes. And did you eventually agree upon a price for this Jeep? Yes. Ms. Nahara says, and Your Honor, I have a document which has previously been marked 138. I'd like it to be marked now Exhibit 137. Court says 137. And ma'am, showing you Exhibit 137, will you take a look at those pages and tell me if you recognize that document? That's a contract. Mr. Levin says, Your Honor, may I have a moment? May I see the exhibit? Court says, sure. Mr. Levin says, Your Honor, I have an objection. We have not been provided with this document before. More discovery issues with this prosecution. I'm not surprised. They love to throw things on them, and their whole plan is trial by ambush, as it seems. So they have not seen this document before. The court says, I got the impression that it was an exhibit from the first trial. Ms. Nahara says, it was, Your Honor. It was previously 138. Mr. Levin says, all right. Court says, do you withdraw your objection? Mr. Levin says, yes, Your Honor. I was talking about today. Ms. Nahara says, and showing you Exhibit 137, again, there appear to be several pages attached to Exhibit 137. Do you recognize these pages? Yes. Now, can you tell us what the first page of Exhibit 137 is? It's a sales contract that the finance office uses. And what is the second page? I would object unless the witness has personal knowledge. Overruled. Can you tell us what the second page is? It's a credit application. Now, when you were talking with the individual, first of all, were you talking with this individual when you were talking with this individual in your office? You said that you were negotiating a price. When you finally agreed upon a price, did you start working on documentation? We did the credit application, as I recall, but the final papers weren't done until a couple of days after that. Now, the documents that you have before you, were any of those documents what you worked on when you were in the office with the defendant and the third person? The credit application only. And what was the agreed upon price for this Jeep? I was under the impression it was around $24,000. Mr. Levin says, objection, Your Honor, unless the witness has personal knowledge. The court says, well, the answer is non-responsive, so objection sustained. The answer is stricken. So you were present when the final agreed upon price was determined. Is that correct? Yes. And do you in fact list that in the documentation that you worked on? I don't do those paperwork. That goes to another office, the paperwork, and it's done on a computer in another office. What did you at any time write down, but did you at any time write down the amount that it would be? It's on a different sheet that the office has. I don't have it. And Mr. Levin couldn't hear that answer. The court says, we'll have the reporter read it back. The last answer was read back. Ms. Nahara says, when you were talking with the individual, the two of you agreed upon a price. Is that correct? Yes. Mr. Levin says, objection with respect to the two. It's vague as to who was the two. The court says, why don't you clarify that, please? Ms. Nahara says, when you finally agreed upon a price, who did you agree upon the price with? With the unknown gentleman, I don't know who he was, and Erik and Lyle Menendez. Mr. Levin says, I'm sorry, The court says we'll have the reporter read it back so you can hear it. The last answer was read back. Mr. Lemon says, Your Honor, I would object. It calls for a conclusion with respect to Erik and Lyle Menendez. Overruled. Ms. Nahara says, and did you agree upon the price of $21,241? Yes, I. Now, after you agreed upon a price, you said that you worked on a credit application, and that is the second page of the documents before you. Yes. And with regards to this credit application, did you have someone fill it out? My manager, I believe, filled this out. It was a cash deal, so we don't need the whole thing, just references. Did you get some information on that form from the individual who was buying the Jeep? Yes. And who is the individual who was actually buying the Jeep? Erik Menendez. And you said that was a cash sale, is that right? Yes. And does that mean that the person doesn't finance it, they just give you a check? Yes. Now, after you filled out that form, at some time later, were you informed that the Jeep had been paid for? Objection calls for speculation, sustained. At some time later, did the defendant Erik Menendez come back to your Jeep dealership? Objection, no personal knowledge unless she has personal knowledge. The court says, if you can establish that, please. Ms. Nahara says, sometime later, were you present? Sometime later, did the defendant Erik Menendez come back to the Jeep dealership when you were present? Not when I was present. My manager was present and took the check. Objection, Your Honor, with a motion to strike regarding what the manager might have done. Objection sustained. The answer is stricken. The jury is admonished to disregard it. Wow, this witness is awful. Ms. Nahir says, sometime after this transaction, were you present when the defendant Erik Menendez took possession of a Jeep? Objection, no personal knowledge. She was asked whether she was present, says the court. Mr. Levin says, when he took possession. And Ms. Nahara says, you can answer that. Yes. Was there an overruled? I didn't hear. Doesn't say, but okay. And after you saw the defendant, Erik Menendez, take possession of the Jeep, did you see him after that? Yes. And was this at the Jeep dealership? Yes. And what did he come back? How many times after that did you see him? 2 or 3 times. And why did he come back to the Jeep dealership? Objection, Your Honor, calls for speculation, and also it's outside discovery. I have no knowledge. The court says objection sustained on the first ground. Ms. Nahara says you were present when he came back several times. Is that right? Yes. And did you see what he did? Mr. Levin says, Your Honor, I would ask to approach. The court says, what was this for? Service on the vehicle? The witness says, yes. And he was customizing, had different things put on the Jeep. We have a gentleman that takes care of that at the dealership. Court says, overruled. Ms. Nahara says, I have nothing further, Your Honor, and we're going to have cross-examination with Mr. Levin for Erik. All right. So when was the first time that you were interviewed by anyone from the prosecution in connection with the case? I don't remember the date. Was it back in 1989 or early 90? I really don't remember. And when was the last time before today that you were interviewed in connection with this case? I received a telephone call at my office 2 or 3 days ago. Is that by Detective Leslie Zoller? Yes. And did Detective Zoller ask you questions in regard to your involvement in this transaction? Yes. Did you tell Leslie Zoller that you believed that in October 21st, talking about Erik saying his brother came back and took possession of the car? No. Mr. Levin says, Your Honor, I have a 1-page report. I would like to show it to the witness. I don't even really want to mark it as an exhibit. The court says, sure. So probably just to refresh your memory. And Mr. Levin says, showing you a 1-page document. You see your name on there, Vicky Rivas? Uh-huh. Would you just read something to yourself in this paragraph that I'm pointing to, the third paragraph, specifically the last line. Witness does so. Did you tell Detective Zoller that on the 21st you believed that Lyle Menendez or that his brother came in and took possession of the car? I don't recall that. Okay, and you weren't even there when when someone came in and took possession of the car, were you? I was at the dealership when they took possession of the car. I wasn't there on the third time that they came in for the negotiating and the paperwork in the finance office. Well, was the car given to Eric Menendez on the second occasion? No. So there was no money given to you on the second occasion, was there? Right. There was no money given to you on the first occasion? No. All right, so the first two times individuals walked into your location, correct? Yes. Now, had you ever seen Lyle and Eric Menendez before? No. Did you ever hear about Lyle or Eric Menendez before they walked in? No. And so two young men walked into Walter Burge Jeep, correct? Yes. And you were talking to those two individuals, correct? Yes. Now, did both of them introduce themselves to you? I introduced myself to them. Well, did one of them say, "Hello, I'm Eric Menendez"? No, I don't remember that. Did the other one say, "Hello, I'm Lyle Menendez"? No. And on that particular occasion, there wasn't any documents that were filled with concerning Eric or Lyle Menendez, correct? Correct. And there wasn't any paperwork given to you bearing the name Eric or Lyle Menendez, correct? No, just a driving license or a driver license? Driving license for the test drive. All right. Do you have a copy of that driving license? It's just a really weird way to say driver's license. Who calls it a driving license? Anyone? Anyone? I mean, yeah, I've never heard it called a driving license. Anyways, he says, I'm not sure anymore. Or she says, I'm not sure. Do you normally take a driver's license and then Xerox it? Yes. For insurance purposes? Yes. And what do you do with a Xerox copy of the driving license? We usually, objection irrelevant, uses it unless it relates to this incident. Court says, well, let's see what she remembers about this particular license. The witness says, usually throw them away. Mr. Levin says, when you throw them away, oh wait, when do you throw them away? As soon as the test drive is over. So in this case, did you do that? Do you remember doing that? I'm quite sure. I don't recall exactly, but I'm sure I did. Okay. And do you record the driver's license information down anywhere? Yes. And where do you write it down? We have a log. All the documents that you've presented here in court don't reflect all the documents that were prepared in connection with the sale, do they? No, of course not. For example, you weren't given any documents that reflect any. Hold on, my screen keeps flickering here. Sorry. For example, you weren't given any documents that reflect any accessories in this vehicle. Right. They included, however, and you seemed a little bit puzzled when you first looked at the document when I heard you say that you thought that the vehicle was 24,000, correct? Right. But actually, taking a look at the document, it's $20,319, correct? He got a good deal. So that was what the document reflects, ma'am. Ms. Nahira says, I'm going to object. The document speaks for itself. Court says overruled. Mr. Levine says, would you take a look at the document that's been presented to you by the prosecution and look at the line that says cash price motor vehicle, and does it not indicate $319. Yes. And the so-called Burge package is the package of customized accessories that you were referring to before, correct? Correct. And this is a common accessory package that's sold all the time at your particular location, correct? Yes. Ms. Nahara says, I'm going to object to that question as argumentative. Court says overruled. Mr. Levin says, Eric Menendez did not come in and say, I want this specific itemized customization to the vehicle. He was purchasing the so-called Burge package, correct? Right. So she's acting like he's wanting all of these whips and or whatever you call not whips and chains. What do you call 'em? Bells and whistles. That's what he's acting like he wants or she is acting like, Eric, or at least the prosecution is trying to make it seem like Eric was just, gung ho with all these bells and whistles that he wanted added to his car and all these different things to customize it, when really he's just getting an upgraded package from the dealership that is probably typical, you know, you get like your baseline and then you get a couple different other versions of, like upgrades to your car. And those all are part of that package. I'm sure that's what's happening here. So Vicky admits, right, it's just part of the package. So this is something that the company presents as a package to customers who routinely want some upgrades, correct? Right. Is that correct? That's correct. And the price of that upgrade is about $4,000, correct? Yes. And you would agree with me that the difference between 20,000 and 24,000 is $4,000, correct? Correct. Well, he got her there. And you don't have any document in front of you to reflect that any customizations were provided to Eric Menendez in front of you now. No. Now, you indicated before in direct examination that the two people that walked in were Eric and Lyle Menendez, correct? Correct. Could you, without looking at the people seated at the council table, who you know to be Eric and Lyle Menendez, can you recall the description of the two people that you saw on the very first occasion that came into the business location? Could you describe them? Why? They're sitting in the room. I can. Actually. Okay, could you? One was wearing a very nice sports jacket with blue jeans, and I don't recall what Eric was wearing, but I did notice Lyle because I thought he looked very nice. Okay. The person that you're referring, or that you're calling Lyle Menendez, how old was that person? Very young. How old? Maybe 20. I don't know. About how tall was he? Probably 5'7" or so. And about how much did he weigh? Probably 160. What color hair did he have? Why are you doing this? He's here. Oh, probably to question her memory. I see. Okay, so what color hair did he have? Brown. And was it long or short hair? Medium hair. Medium, not long, not short. Was it light brown or dark brown? Medium brown. Medium brown hair? Mm-hmm. Was his hair curly or straight? I think it was straight. Was he wearing sunglasses? I believe so. And what time of day was this? I don't remember what time of day, but I know it was in the midweek. It wasn't a weekend. And the person that you believe to be Eric Menendez, about how old was that person? He looked very young. How young? 19 maybe? And about how tall was he? Probably 5'8". About how much did he weigh? 150? I'm not very good at weights. He weighed a little bit less. He weighed a little bit less than the other person, I would say. Was he taller or shorter? Taller, I thought. A lot or a little? A little taller. Did he have any facial hair, mustache, beard, or goatee, long sideburns? No. Did the other person have any facial hair? No. Now, the only reason that you're saying that you believe that the first occasion that those two people were Erik and Lyle Menendez is because someone at your business told you that that was Lyle and Erik Menendez, correct? Objection argumentative and calls for hearsay. Overruled. You can answer the question. The witness says yes. So let's back up. The only reason that you're saying that you believe that the first occasion that those two people were Erik and Lyle is because someone at your business told you that that was Erik and Lyle. She says yes. So, after you dealt with the two individuals that came in, someone came up to you and said, "That's Erik and Lyle Menendez, correct?" Correct. So, she did say they didn't introduce themselves. So, how does she know that the people that she's talking about and the memories that she's having are Erik and Lyle? And that's hearsay, so this shouldn't matter. Like if she's getting it from some other source. So it's like hearsay upon hearsay almost. And then you were also told some information about a tragedy that happened within the Menendez family, correct? Right. Now, up to that time, you had not seen either Erik or Lyle on television, had you? I don't believe so. Well, if I was to represent to you that this is now almost 6 years ago now, it's October of 1989, they weren't even arrested until March of 1990, would it make sense to you that you hadn't seen either of them on television? Yes. And you hadn't seen either one of them in the newspaper? Right. So the second time that they came back, are you absolutely positive that it was the same two people that came the first time? I know you said three, but I'm talking about the two people that you believe to be Erik and Lyle Menendez. Are you absolutely positive that it was the same two people that you had seen a few days before? She says yes. Well, you had no reason, did you, to pay any particular attention to them on the first occasion? It was a pending sale, and I knew they were interested in a Wrangler. About how many people do you deal with on a typical day? Between about 40 people. So 30 or 40 people. And how many days elapsed between the first occasion when you saw the two people and the second occasion when you saw three people? I believe 2 days. 2 days later? Mm-hmm. So on this second occasion that the third person came along with the two, did this person identify himself to you? He must have, but I don't recall his name. Do you recall describing him as tall and skinny with a Jewish sounding name? I think so. Does the name Steve Goldberg, an attorney named Steve Goldberg, ring a bell with you? It sort of sounds familiar, but I can't absolutely be sure. Is Goldberg a Jewish sounding name to you? Yeah, yes. So, does that sound familiar to you as possibly the person? It's possible that returned. Now, isn't it true that Mr. Goldberg, or whoever that third person was, clearly indicated to you that he would be doing all the financial arrangements and negotiations of the sale of the Jeep, or if the sale of the Jeep were made? Yes. And that you should direct all of your negotiating and discussion of prices with Mr. Goldberg? Yes. And that would mean that you weren't to discuss financial agreements with Erik Menendez, right? Or and he answers, or she. Why I keep saying he? She answers right. Now, looking at Erik Menendez's, start that sentence over. Now, looking at Erik Menendez seated in court, do you have an independent recollection of Erik Menendez, the person who I touch on the shoulder in the yellow striped shirt, as being the person that you saw back in 1989? Yes. And you remember him from seeing him now in court? Yes. All right. Now, that Jeep that you sold to Mr. Goldberg, or that was ultimately acquired by whoever, did this vehicle have any air conditioning? I don't remember. Now, air conditioning is an upgrade, is it not? Yes, it is. So you don't, air conditioning is an upgrade? You don't remember whether this vehicle had an air conditioning system. Yes, I don't recall. And that would be extra, correct? Yes, it would. Hundreds of dollars extra? $1,000 extra. So $1,000 extra. Now, did the vehicle have an upgraded sound system? No. And this is something, an upgraded sound system that your business is capable of installing in a vehicle should someone request it. Yes. It's commonly done, is it not? Yes. People ask for upgraded sound systems and upgraded speaker systems. Yes. And with CD players and things like that. And it might have been done, but you don't remember it being done. Right. And there's also other options or customizations that could occur to a vehicle other than the Burge package, correct? Correct. And you don't remember if any of those other accessories were placed on this particular vehicle, do you? No, I just know it was a pretty loaded vehicle. Who did the prosecution tell you to say this? Like, they're really pushing the angle of the money hungry stuff now, and more so than they did in the first trial. So they're really going after the money motivation, going for the inheritance, which is so stupid. But that's what they're going with. So here we are. Okay, with the Burge package, correct? Yes. And other than the Burge package, it would have been custom. I mean, it would have been just a stock vehicle. Yes. You sell a lot of vehicles with Burge packages, correct? Yes. And am I correct? This is a Wrangler 4x4 Jeep that is stock. Does it have a soft top with it? Either soft or hard top. So when it's a soft top, do you call it a convertible? No, they're all convertibles. So every single Jeep Wrangler sold in the United States is a convertible. Yes. There's nothing extra special about the fact that the top comes off. No, it's standard. Yes. Do you recall the engine? Was there a stock engine? It was a six-cylinder, which is a standard stock engine, correct? There are four-cylinder or six-cylinder. This was a six. She's still not answering the question. And the Jeep line of products has a more expensive vehicle, does it not, called a Cherokee? Yes. And is there also a Grand Cherokee? Yes, not in 89, however. In 89, there was no Grand Cherokee? Right. That was a newly introduced item. I want to ask you a couple of questions about the demeanor, the way in which you perceived Erik Menendez during those two contacts that you had with him that you testified to today. Would you describe his demeanor as not being overly friendly? He wasn't overly friendly, but he didn't appear to be. Excuse me, Your Honor, I believe there's more to the answer. The court says, had you finished your answer? The witness says yes. Mr. Levin says, he did not appear to be particularly enthusiastic about this particular purchase to you. No. And you had been told, had you not, of the tragedy of the Menendez family, correct? Correct. And you were aware of that when you saw Erik Menendez, correct? Correct. And you knew that his parents had their lives taken, correct? Was there anything in his demeanor and the way in which he acted that you felt was inappropriate with the information that you had about his family or about his mother and father's lives being taken? No. So he was acting appropriately with respect to the information that you had? Yes. Ms. Nahir says, I'm going to object. No foundation as to what is appropriate. Overruled. Well, he's not like jumping up and down on the couch and, flying around screaming and going, oh, my parent, like he's acting normally. He's acting appropriately in a situation where he would purchase a vehicle and he wasn't overly emotional. That's what that means. Mr. Levin says, I'm sorry, what was that? Was that yes? Your answer. And the witness says yes. Mr. Levin says, now, with respect to the negotiations with Mr. Goldberg. Mr. Goldberg, I take it when a moment ago, you looked at this contract price and your reaction was he got a good deal. Is that correct? Yes. So, Mr. Goldberg, in negotiating the price of this vehicle, would you agree was rather aggressive in trying to get the best price possible for the particular vehicle? Objection calls for speculation as to what Mr. Goldberg, well, assumes a fact, not an evidence. Mr. Levin says, I understand. Ms. Nahara says, and also calls for speculation as to what he's trying to do. Court says, sustained. Mr. Levin says, this third person who's doing the negotiation, I've been calling Mr. Goldberg. Would it be a fair statement that Mr. Goldberg was trying to arrange for the best price possible, the lowest price possible? Yes, of course. Objection, it calls for speculation as to what Mr. Goldberg wants to do, what's in his mind. Overruled. The answer will stand. Who wants to pay more for a car? Like, what a dumb. Shut up, Ms. Nahira. Go sit down. Mr. Levin says, was there anything done with respect to the sale where there was any kind of secrets that were being gone on, any whispering, any unusual kind of negotiation where you weren't supposed to say anything with respect to the sale or anything like that? No. After you completed the sale, I take it at some point in time you heard that there was a trial going on in this case. Yes. And that trial involved Erik and Lyle Menendez as defendants. Yes. Now, did you have any particular interest with respect to the first trial where you would, when you could, watch television accounts of this case? Somewhat, yes. Thank you. I have nothing further. Did you have any particular interest with respect to the first trial where you would then, when you could, watch television about the case? So she's kind of a true crime junkie, like all of us. She wanted to get into she wanted to learn more about this case. So she's skewed. She's definitely, she's been tainted. But she says somewhat, yes. Mr. Levin says, thank you. I have no further questions. And the court, uh, there will not be any questions from Lyle's side. Again, I don't know why they don't do questioning. They really shouldn't waste an opportunity to question someone. I mean, I know that, it's a choice as to whether you're going to cross-examine someone or not, but in this situation, like you're fighting for it's death penalty case for the brothers. And you're just gonna, nah, just let the witness go. You're just not gonna ask them anything? Got it. Okay. Anywho, Ms. Nahara asks, now, Ms. Rivas, with regards to this third individual that Mr. Levin was talking to you about, which he is referring to as Mr. Goldberg, this individual, did he buy the Jeep or did the defendant Erik Menendez buy the Jeep? Erik bought the Jeep, but the gentleman negotiated the price. So when we say he bought the Jeep, that means Erik Menendez paid for the Jeep. Is that right? Mr. Levin says, objection, calls for speculation. The court says, sustained, the answer is stricken. The witness says yes. You weren't supposed to answer. Okay. So then this witness is terrible. Then Ms. Nahara says, in the form that Mr. Levin just referred to you to, I believe it's the first page of the document before you. Is Erik Menendez listed as the buyer? Yes. Does there appear to be a signature of Erik Menendez in several pages of that page? Mr. Levin says, objection, Your Honor, calls for speculation unless she has personal knowledge. The court says she's asked, does it appear to be? Overruled. Ms. Nahara says, you can answer the question, yes. And you said that at the time that Erik Menendez came in to purchase the Jeep, he didn't appear particularly enthusiastic. Is that your testimony? Yes. And when you say particularly enthusiastic, what do you mean? Well, people show differently when they're buying a car. A lot of people are worried because they're spending a lot of money. Other people are just happy to buy a car. Now, the defendant, Erik Menendez, did he appear worried to you? No. And people who worry about buying the cars, is this due to the price? Wow. Wow, you're reaching. So he didn't appear worried, so he's not, obviously, he's doing this all for the money. Got it. Mr. Levin says objection, calls for speculation, overruled. And the witness says normally. I believe that came in, but here we are. Ms. Nahir says, and you didn't see that kind of worry on the defendant, Erik Menendez, when he came in to buy the Jeep. Is that right? Objection to that kind of worry. There's no foundation. Sustained. Did he, being Erik Menendez, seem serious about buying a car? Yes. Did he take time to consider the different custom options that you were providing? Yes. And on occasions after that, when you saw him come in to do various custom things, did he seem pleased with this vehicle? Yes. And did he seem happy with it? Yes. Ms. Nahira says, thank you. I have nothing further. Anything else? We have a little bit of recross with Mr. Levin. All right, so just with respect to the signature on the form, would you take a look at that? You can read that, can you? The signature? It's difficult. Well, being difficult, it's just some scratching, is it not? It's going, or Ms. Nahir says, I'm going to object as argumentative. Overruled. Can't read mine neither, says the witness about her own signature, I guess. So Mr. Levin says, okay, well, whether you can read yours or not, because you know you wrote it, just looking at that mark and asking you for a fair and honest answer, can you read what that scribble says? No. And were you there when that scribble was made? No, that was done in the finance office. So you don't know who made that scribble, do you? Right. And the person you told Ms. Nahara that, and the reason that you told Ms. Nahara that was Erik Menendez's signature is because you knew she wanted you to answer that way, right? No. Well, then why did you say it? Well, I don't think anyone could read Erik Menendez. Well, how? But you never saw the person write this particular signature, did you? No. And you can't read it on your own, can you? But it's registered to Mr. Menendez. Well, wait. Ms. Nahara says, Your Honor, Mr. Levin says, that's not what you were asked. You were asked, what does that signature say? And you asked Erik Menendez, correct? Correct. Thanks. Or answered, sorry, answered. And you said, I can't read or focus. My brain's gone now after reading this for so long. Mr. Levin says, thanks, nothing further. The court says, anything else? Ms. Nahara says, nothing further, Your Honor. The court says, okay, thank you. You may step down. Ms. Nahara says, Your Honor, can we approach? And the court says, yes. The following proceedings were held outside the presence of the jury. All right, so the court says, yes. Ms. Abramson says, I was just going to ask for a little extra time, a break now. My client is not keeping it together this morning, and I'm not exactly sure why. He's been crying, and he's very tearful. He's not exactly with us at the moment. It's hard for him to follow the proceedings, and we really haven't had much time to talk to him today to find out all the dynamics, but I do know, as the court is aware, that he's under the the jail psychiatrist's care, that various medications are prescribed for him. They have varying effects. I have noted, so he's going through, probably chemical imbalances and things. I've noted actually since the start of the testimony this time around that he is having a much harder time dealing with just sitting there and listening. He's hyper anxious. The court says, you're asking to recess now until 1:30. Ms. Abramson says, yeah, I just want to do that. The court says, your next witness is Slotkin. Ms. Nahira says, yes. Court says he's sitting in the audience, so we wouldn't be finished by noon anyways. So we'll recess now and come back at 1:30. Ms. Nahara says, could you order him back? Ms. Abramson says, on that point, we've been told repeatedly that the only thing that's going to be asked about Mr. Slotkin is he owed my client some money for a Lake Tahoe debt. Are we on track? Ms. Nahara says, you're condensing it. I'm going to ask him about Lake Tahoe, going to Lake Tahoe and gambling. The court says, let's talk about that after we excuse the jury. Ms. Nahara says, that is what I'm going to be offering. So whenever we go from there. And the following proceedings were resumed in open court in the presence of the jury. Jury's back. And okay, the court says, okay, the lawyers have a matter. It says in the presence of the jury. Court says, the lawyers have a matter they want to talk about with me a little further, so we'll take our recess. Oh, they sent the jurors out. They brought them back in so that he could say, we're sending you out again. So we'll have our recess for the lunch hour and have you come back at 1:30. Don't discuss this matter with anyone. Don't form any final opinions about it. We'll see you back here at 1:30. The jury exited the courtroom and the following proceedings were held. Court says, all right, while we're waiting for the jurors to leave the courtroom, the jury room, rather, Ms. Nahara says, we have one witness we need ordered back. The court says, we'll keep Mr. Slotkin here just in case we have to talk further about his testimony. What was it that you wanted to know? Ms. Abramson says, I want to know what they're going to elicit from him. We're not getting updated discovery in this case. We hear things for the first time on the stand. My understanding is that the court had ruled. Ms. Nahara cuts her off and says, Your Honor, can we have Mr. Slotkin step out while we discuss this? Court says, you can wait in the hallway, Mr. Slotkin, but we also want you back at 1:30, and that will be the end. Ms. Abramson says, my understanding was, the court says, wait, we're going to let the jurors out. The jury exited the room. Ms. Abramson says, I'm sorry, Mr. Levin will be handling the witness, but I think my memory, we had litigation about the retrial concerning proffer. And the court says, right. Ms. Abramson says, my understanding was that Mr. Slotkin is being called solely as another so-called spending witness, and the specific spending involved is an amount of money $4,000 to $5,000, which Mr. Slotkin loaned to my client to cover the loss by Erik Menendez. He supposedly lost that, and he needed that money to get home or something like that. And that's fine if they want to put him on the stand to say that. Did you loan him this amount of money at this time, and did he tell you it was for that? Fine. Goodbye. Things don't work that way in this trial. This time around, it seems. So now Ms. Nahara has indicated briefly in the hallway, well, she wants to get into the whole Tahoe trip and all the gambling, and we have not been given discovery of that. The court says, I don't recall that Mr. Slotkin was present or for any gambling from the offer of proof, that there was just reference in the people's proffer of evidence that he would testify that he was with Erik Menendez in Lake Tahoe and that Erik Menendez asked to borrow money to pay a gambling debt. Is that right? Ms. Nahara says, that's exactly right, Your Honor, and in fact, page 1197 of the discovery that I have given them, fifth paragraph down, that paragraph is what I intended to ask him about. Miss Abramson says, well, I would. The only thing from that paragraph that the people have proffered is that Erik told him that he lost $4,000 to $5,000 gambling and Mr. Slotkin paid him. Period. Spending the time skiing, returning home. I mean, you can say that's all. That takes a minute and a half to elicit from a witness. Why do I think it's going to take them 20 minutes to talk about going there and being there and doing things? If I'm wrong, fine, but I suspect I'm not wrong. That that what they're trying to elicit is how long he stayed, and wasn't this an expensive hotel in this best part of town, and didn't he have a good room and all this usual. Exactly, that is what they're doing. I want to make sure that we're not going to have another one of these little soap operas that They're going to put him on for one thing, and we're going to have another day in the life of Mr. Menendez. The court says, remember those remarks when the defense begins. Remember them. Put them in a little plaque somewhere. Are you kidding me? They have been sandbagged over and over again by the prosecution, and the judge is like, F you for pointing it out. And I'm gonna hold you to the same standards, but he's not holding the prosecution to any standards. So this is total bias and total holy cow. Like, it blows me away sometimes. The incredible bias and disrespect also of this judge. Miss Abramson says, not fair, Judge. That's not fair to say that. He's sitting here crying right now, Judge. The court says, I'm telling you, I'm responding to you. Ms. Abramson says, I know you're responding to me, but it's a whole other matter. Court says, what is your offer of proof? Ms. Nahara says, my offer of proof. Actually, I wasn't planning on going into where they stayed or anything like that. I don't have any information of that. What I have is these lines, and I'll read them to the court. Quote, Mark said that during the week of Christmas to New Year's of 1989, he, with a few friends, flew up to Lake Tahoe. Erik went along with them. Erik lost 4,000 to 5,000 gambling, which he had to borrow from Mark to cover the debt. When they returned back home, Erik paid him back. That's it. Court says, okay, all right, anything else? Now, before we take our break at 1:30. Okay, we'll see everybody back at 1:30, and at 11:50 p.m. the noon recess was taken until 1:30 of the same day. Now we're back, and the court says something you wanted to talk about before we have the jury come out. Ms. Nahara says, yes, Your Honor, the people proposed calling Mr. Slotkin criminalist Gross and the deputies Dulla and Guthrie. I have the 9-page report, which we refer to as the escape plan. And, Your Honor, we have copies of the escape plans, and I've spoken with defense counsel about how we propose to basically give the jury the information that is in the escape plans. There had been there had been some objection earlier by counsel that they did not want us reading parts of the escape plan and them referring to and then referring to them. I believe Ms. Towery said there was a best evidence rule problem. What we propose to do with Deputy Guthrie or Detective Zoller, we've made copies for all counsel and the jurors and alternate jurors and the court. Pass them out at this time. Take a shot. Pass them out at this time and have either one of these two officers, detectives, read them to the jury so that the jury will have this in front of them. Or we can give the jury one copy and have each juror read that. Or give the jury the 18 copies and have them all read it. Our concern is it's an important piece of evidence that we want to get to the jury. We don't feel it's appropriate to hide it from them until the end of the trial, and they are going to get the opportunity to examine them and look them over. The court says, first of all, it has nothing to do with the best evidence rule. The exhibit is right here. The issue is how to introduce it as an exhibit. And Ms. Nahara says, correct. The court says, let me hear the defense. Ms. Amerson says, we object. Towery says, we join. Court says, okay. Ms. Amerson says, my understanding is that they're not playing a tape. This isn't a transcript of the tape. What they want to do is highlight and duplicate one piece of evidence unduly and give it to the jury. I don't know of any precedent for doing that and how the deputies should deal with the escape. I defer to co-counsel concerning this evidence being introduced. For my purposes, presenting my client, I think it's improper to highlight this by giving it to the jury in that form. Ms. Towery says, it's also a document that has yet to be authenticated, yet to be admitted into evidence. There may be objections that arise during the course of the testimony, and I've never seen a handwriting analysis of this document as being Lyle Menendez's handwriting. So it's prejudicial to permit the jury to read through these documents as if They will be allowed to look at them in the jury room at the end of the case. The court says, well, first of all, the deputy sheriffs have no knowledge of this document, only that it was found. They have no information about how it was generated or produced or any information about the contents of it, any more so than the jurors would be reading it. So they're talking about this escape plan. The brothers Lyle supposedly had an escape plan, and these letters or plans were written, and the corrections officers found them in their cell or something, and they got busted with it. So here's the they're trying to introduce it, but they can't because it's not authenticated unless Lyle authenticates it. And Lyle isn't taking the stand this time around. So that's what they're arguing here. So at this point, my view is this is an exhibit that is one that would be presented to the jury in the usual fashion of exhibits being received in evidence at the end of the trial. And if it is received and given to the jury to evaluate, the lawyers can argue the contents of it and describe it in as much detail as they want during their argument. But this is not argument at this stage. This is just testimony from the person who found the document to identify it, authenticate it, and nothing more. This is nothing to do with a document that was created by the individual who's testifying, wherein that individual could be questioned about testimony. It's nothing to do with a document that the witness has any firsthand knowledge of other than the fact that he found it. Nothing more. So I don't think it's proper at this stage for the document to go to the jury or for it to be read to the jury. Ms. Nahara says, with regards to reading it, I understand what the court was saying, and it would seem to apply to them being handed one to read. However, if this document were blown up and the deputy identified each page as something that he saw, that would put this document before the jury and they'd have a chance to see it and read it. Put it up on a blackboard before it went to them in the jury room. We think it's appropriate that the jury be allowed to know what's in these pages as opposed to keeping it a secret until they're back in the jury room and get a chance to read it and find out what it was that we're all talking about. The court says no one is keeping it secret. Ms. Nahara says, I think it's unclear. The court says that's contrary to what is happening. The document will be identified, and before it goes to the jury, if it's a significant piece of evidence, counsel can argue it in length to the jury. So it will be given to the jury and in an appropriate fashion put in the context of the overall case by argument. And at this stage, I don't see any reason to introduce it to the jury in any fashion other than the document being identified by the witness. So the request to use an enlargement is denied as well. Haha. Big ol' loss for the state, finally. Ms. Towery says, Your Honor, with respect to these documents we discussed quite some time ago, when we were litigating the admissibility of the documents, the reference to the documents as escape plans, and I think we called them so-called escape plans, but we would object to either the prosecution or the deputies characterizing these documents in that fashion because it is an opinion on the part of the deputy as well as the prosecution as to what these documents constitute. The court says, obviously, during argument, the prosecution can characterize it any way that they feel is appropriate. That is not an argument. That is not true. Like, you can put limitations on what they argue if it's not appropriate evidence. So he's just flat out wrong there. Ms. Towery says, my objection goes to examination of the witnesses to that use of that particular term with respect to those documents. Secondly, there was a reference on a couple of pages of documents to someone named Ed, and there was testimony before the grand jury as to the identity of an inmate on that row by the name of Eddie Nash. And I do want to object to the prosecution bringing any such testimony out as also improper speculation, opinion, conclusion on the part of the deputies, and that not happen either purposefully or inadvertently in the course of the examination by the prosecutor. Sorry, she's hearing dogs bark in the background, so she's got to bark too. Ms. Abramson says, "Excuse me, Your Honor." Attorney Abramson and Towery confer. Ms. Towery says, "Initially, I would broaden that objection to ask that the prosecution not be permitted to focus specifically on any names or offer any part of the documents. Again, the documents speak for themselves and are subject to argument by counsel. They're subject to varying interpretations and have been vigorously argued before the court as to what they mean, if they mean anything. I would ask counsel be precluded from going into any specific aspect to the conclusion of other aspects of the documents." The court says, "What did you intend to do in that regard?" Ms. Nahara says, "Your Honor, I think I need a little clarification from the court. The court has ruled previously that we can't refer to these plans as escape plans. Now Ms. Towery says we can't refer to anything about these, and now I'm a little bit at a loss. The court has just stated we would be allowed to put these documents before the jury and identify them. It sounds like counsel is suggesting we put these documents before the officers, ask them if they found them, and say, okay, they found the documents, without the jury having the slightest idea why we are asking or why we are doing this. That is my concern. I think counsel has just illustrated the problem I'm having here, the dilemma I'm having. We put these documents in, and the jurors say yes, we put in the documents. Then they have to wait until the end of the trial to know what on earth we're talking about or how it fits into the whole trial. The Miss Towery interrupts and says the deputies aren't qualified to interpret the documents for the jury. Again, there are many ambiguous statements in the documents and in the prosecution. If the prosecution is allowed to isolate specific portions of the document in direct examination that they believe enhance their case, obviously the defense would be required to go through other aspects of the document that the defense believes diminishes the prosecution's case. And the problem is that these deputies aren't qualified to testify about anything other than that they recovered the documents and booked them into evidence, and they're not qualified to give an opinion as to what they mean. They're not qualified to isolate portions of the documents that are more important than other portions. They're not qualified to give any sort of interpretation to the documents. They're not experts," Ms. Abramson says, "or to read," and Ms. Towery says, "or to read selected portions from the or before the jury. So we would object to any such testimony elicited on the part of the prosecution, again necessitating the same kind of testimony on the part of the defense, all of which is improper, and that the documents simply be authenticated, which is all these witnesses really can do." The court says the last colloquy is a reaction or response by the prosecution as to what you intended to do. That's all I asked. I didn't ask whether you were in a quandary. I just wanted what did you propose to do. Ms. Nahara says, "I had told the officers they are not to refer to them as escape plans. I proposed to ask them what was in these documents that were relevant to why they seized them." Court says, "Why would that be relevant to the jury's role in deciding the relevance of this document in regards to this case? Why they seized them? What does that have to do with the jury's decision in this case?" Ms. Nahira says, "My understanding is that the reason that we are presenting these to the jury is that they are circumstantial evidence of escape plans and that this is why they are relevant. Now we're presenting them to the jury as documents, and it seems like there's no way to describe them, so the jury understands why they are relevant other than just saying documents. And I guess what I intended to do was simply have the deputies explain what they were so they'd know. They'd have a description of what they are besides just documents." Court says, "Well, they're going to have the exhibit at the end of the trial. I don't understand what your problem is." Okay. Okay. That right there just kind of made me like Judge Stanley Weisberg because he just told the prosecution, "I don't know what your problem is. I just don't follow what your problem is," he says. That's pretty funny. I'm sorry. That's great. Ms. Nahara says the only problem, Your Honor, is what is going to happen here is the deputies are going to take the stand, say we found documents in the jail cell of Lyle Menendez, and leave the stand. And the jury is going to look at all of us and say, that's nice. What's the relevance of that? There's no evidence of what they are because they don't see what the documents are. At the end of the trial, they'll be able to see what they are. Maybe I'm mischaracterizing when I say we're hiding the information. It seems like we're not getting information to them when there doesn't seem to be any reason not to. The court says, how are you going to get to? Ms. Nahara says, one is to offer to the escape plan, or is to refer to the escape, blah, blah, blah. One is to refer to the escape plans. The court says, how could you possibly have a witness come in and characterize it in that fashion? You keep arguing that as though that's a meritorious position. Ms. Nahara says, sorry, Your Honor, I didn't hear the last thing you said. You keep arguing it as though you have a meritorious position that these should be characterized as escape plans, that that the deputy sheriffs should be able to come in and characterize them that way. That's clearly inappropriate. Good. Tell her, judge, for the first time, do something good in this case. Ms. Nahara says, I guess my position is they need to be characterized one way or the other than documents. If we're not going to characterize them, which the court seems to be saying it's inappropriate for the lawyers to characterize these documents as anything, then it would seem to be appropriate to pass them out and let the jury see them for themselves. We've had situations in the past in this courtroom where the defense has given photos to the jury. We've put up photos for the jury to see, show them what we're talking about. And in this case, it would seem we are not to characterize them as anything, but they are a pertinent piece of the relevant evidence, which the court ruled they are. Then we should be allowed to let the jury see it now as opposed to not seeing it until the end of trial. That's what I'm saying. The court says, I understand that. Do you have blow-ups of these? I can get blow-ups of this. And where are they? Uh, what I did is made 18 copies. Do you have blow-ups? I can have blow-ups made this afternoon. If you have blow-ups, you can present it to the court and we'll look at them and see if they conform to whatever redacting had to be done. Ms. Nahara says, I've given the redacted copies to the defense and they have agreed they were properly redacted. It would be a blow up of the redacted copy I've given to counsel. The court says, let's see what you produced before they testify. Are we ready to proceed? I cannot believe he's letting it in. He was all about like yelling at the prosecution and suddenly he's just like, no, you can have it. What? Like he was all about admonishing the prosecution for being in the wrong here, and now he's like, well, just, put the blow-ups together, and like they're not even made. They're not even made yet. And he's like, go ahead and make them. And if they work, we'll use them. What? Are you kidding me right now? This is insane, this judge. All right, one more thing, says Ms. Towery. One other issue with respect to Mr. Gross. Ms. Nahara asked me just before the court came out whether or not the defense would have an objection to the prosecution having Deputy Gross identify the handwriting exemplars that he used. He's the questioned document examiner with respect to the ATF records, whether they are the signature of Donovan Goudreau on the shotgun purchase and the questioned documents are among the question documents and the primary ones that he used to make his determination with respect to Lyle Menendez was a 17-page letter recovered from the cell of Erik Menendez. Now, being that document was provided to Deputy Gross as a sample of known handwriting of Lyle Menendez, he did use that in making his evaluation. And Ms. Nahara, the other document used with respect to Erik Menendez was the screenplay. And I believe that Erik Menendez has an objection to the use of the screenplay in the testimony of Deputy Gross. I have an objection to the use of the 17-page letter to question Deputy Gross, and in fact would oppose to inquire of him about that particular document myself, particularly given the fact that he testified at the last trial that he cannot eliminate Lyle Menendez as the writer of the signature of Donovan Goudreau and indicated that there were basic letter formation differences between the question document and Lyle's known writing exemplars. So there you have it. So I would propose to cross-examine him about the document. I don't know if the prosecution has any objection to that. They haven't so indicated to me, but I did want to alert the court. The court says, okay. Ms. Nahara says, Your Honor, I believe that we had, I'm not sure, but I know the 17-page letter was not proffered by the people. My only concern is that I believe it was discussed at one time at the court, and the court ruled we were not to go to the 17-page letter. It was not to be admitted into evidence in this trial. I told both counsel I didn't intend to open the door to either of these documents by referring to them in any way or form. I was going to have Deputy Grose referring to simply writing samples. I don't believe that counsel should be allowed to go into this 17-page letter. I believe at one time there might have been an objection by Erik Menendez, but I don't know. The court says, no, it was the people who objected to it. Ms. Nahara says, we would object to the 17-page letter being referred to anything in the contents of it. Ms. Towery says, Your Honor, my recollection of the litigation regarding the 17-page letter was that the defense argued that the 17-page letter was part of a parcel of the supposed escape plans. As the court will recall, the deputies searched both Erik and Lyle's cell at the same time and culled out documents with Lyle Menendez's cell from Lyle's cell that the deputies felt related somehow to an escape, but did not do the same thing with respect to documents recovered from Erik Menendez's cell. And I think, to the court that these documents were part of the same series of documents and also should come in under Evidence Code 356. The court denied that argument and ruled the escape plan 17-page letter was not part of the so-called escape plans because of the geographical location when recovered, and that, therefore, would not apply. However, the court has never ruled that the letter can never come into this trial, and by putting Deputy Grose on the stand to testify to his opinion regarding the handwriting exemplar, the people have placed that in issue with respect to Lyle Menendez. Ms. Abramson says, I just want to make it very clear on the record that we firmly object to any reference whatsoever concerning the screenplay since the court has ruled that that's not admissible. The court says the people indicate they're not going to refer to that document other than to say that they referred to specific or Mr. Grose referred to specific exemplars. My only question is if there is cross-examination of Mr. Grose where he is asked about the exemplars that were used, would not those documents have to be shown to him so he can indicate what it was that he looked at and what characteristics he found that were the same or different? Ms. Nahara says, That is true, Your Honor. My only concern is whether or not counsel is planning to go into the substance of these 17-page letters, which I think is admissible. The court says, You mean the actual meaning of the words or the right? Ms. Towery says, I can answer that, Your Honor. I have no intention to go into the meaning of anything. I do intend to view the documents that he used, and if he has notations on any portions of the documents, I intend to ask him about those notations. The court says his notations, not the words that were written about other people. It's an analysis of letters and words. His notations are about words written by other people. The court says, I can't rule in a vacuum until I hear what the questions are. I can see that the exhibit that is used is as an exemplar that is subject to questioning might be offered at some point in the trial if it is used during questioning, but we're not at that stage yet. Anything else before we proceed? Ms. Abramson says, We're ready. And the court says, okay, let's get the jury out, please. And we are going to get started on Mr. So Mark Slotkin is called to the stand. He's sworn in and all that good stuff. Direct examination by Ms. Nahara. Sir, in August of 1989, were you aware of the name Menendez? Sometime in August, yes. And did you hear about the homicides of Jose and Kitty Menendez in August of 1989? Yes. And do you recall when it was that you heard about the homicides of Jose and Kitty? I heard about it the day of the discovery of the bodies. And sometime after you heard this information, did you go to 722 Elm Drive? Yes. And did you understand 722 North Elm to be the Menendez residence? Yes. And do you recall how long after you heard about the homicides of Jose and Kitty Menendez that you went to 722 North Elm? Mr. Levin says, Your Honor, at this point, I'd object. It's beyond the scope of the proffer. The court says, all right, objection sustained. So that's a win for the defense. Ms. Nahara says, Do you know the defendant, Erik Menendez? Yes. And is he present in court? Yes. And could you identify him for the record? He has the yellow shirt and brown tie on. And at Christmas, they didn't even say, like, let the record reflect that he's identified the defendant. That she just skipped right over that. And at Christmas of 1989, did you go somewhere with defendant Erik Menendez? Yes, I did. And where did you go? To Lake Tahoe. Did you go alone, or did you and Erik Menendez go alone, or did you go with other people? We went with other people. And why did you go to Lake Tahoe? To celebrate Christmas and New Year's. And when you were in Lake Tahoe, did you lend the defendant, Erik Menendez, some money? Yes. And how much money did you lend him? My recollection was about $8,000. And why did you lend him $8,000? I said my recollection was, I'm sure it was $5,000 at least, but I'm not sure it was eight. I think it was eight. What? Okay. So how much do you think it was? Somewhere between 5 and 8,000. Okay. And going back to my original question, sir, why did you lend him between 5 and $8,000? Well, it didn't start out to be. Objection, non-responsive, Your Honor. Sustained. Re-ask the question. Thank you. Can you tell us why you lent him between 5 and $8,000? Erik wanted to gamble. And did you lend him this money to gamble? Yes. Do you know if he won or lost? Objection, irrelevant. The court says, well, it would call for a conclusion on the part of the witness unless he was there. Ms. Nahara says, were you present when Erik Menendez gambled in Lake Tahoe? Some of the time. And did he win or lose? Objection calls for conclusion. Overruled. He lost, says the witness. And did you lend him this money after he lost or before he lost? Before he lost. And do you know if he lost all of this money gambling? I think he lost it all, yes. And when you say gambling up in Lake Tahoe, what exactly did you see him do? Erik played various games of chance. I mean, these kids are like 18, 19 years old. Are you allowed to go gambling at that age? Or I don't even know what the legal gambling age. I've never been into gambling. I don't care about it, but like they're kids. Are they even allowed to just go and gamble? I need to know what the legal gambling age is. Hold on. Okay, so I'm not crazy. The legal gambling age, I grokked this, which is like a bajillion times better than Google, and I will never go back. So Grok says, if you're not familiar, it's from X. So Grok says the legal gambling age in Lake Tahoe in 1989 was 21. This applies specifically to Nevada and blah, blah, blah. So, okay, so it was 21. I'm not going crazy. Like, obviously they're using fake IDs or something, but they're kids. Like, how are they getting away with this so much? that they've got these fake IDs and getting into these bars and casinos and things when they're not of age yet. But anywho, okay, I'm glad I looked that up because I'm like, isn't it 21? But anywho, he is, yes, they were under 21, but they were gambling, and I'm sure they got in with some fake IDs. And Mark Slotkin says, I think he lost it all. And when we say gambling up in Lake Tahoe, what exactly did you see him do? Erik played various games of chance. He played baccarat, craps, maybe blackjack. I'm not really sure. And he lost occasionally. And when he lost and he was out of money, he came back and asked me to loan him some, that he would pay me back at the end of the trip. And I obliged him. And when you returned, did he pay you back this gambling debt? Yes, he did. Nothing further. Like, okay, but whatever. Like I don't think this is the big get that they think it is, you know? I mean, these kids had money. They lived a luxurious lifestyle, whether we want to acknowledge that or not, whether we like it or not, and whether we're jealous of that or not. We have to accept that. And th- them spending money after the crimes didn't mean, like, that doesn't mean anything because they spent money before the crimes. So to them, money has always just been there. So it's never been an issue. And now they've never had to do it themselves. They never had to be responsible themselves with the money, but now they have to, you know, be the ones to spend it versus their parents. Although we know that Lyle Menendez had his own credit card that he was able to use, and they were able to spend money. They had money and access to money. It's not like, the parents, that was the one and only thing that they allowed the boys to do, was to have money. Everything else, oh, totally under their control. All right, let's move on to cross examination. We've got Mr. Barry Levin, aka Richard Gere from Pretty Woman. As you can see in the picture, I think he looks like Richard Gere there, down below. And yeah, so let's get started here. Oh, and Barry Levin is the attorney for Erik. I know it's on the screen, but just a reminder. All right, so he says, "Hi, how are ya?" Mr. Slotkin, Mr. Slotkin said, "Hi, how are you?" Sorry, I got a little ahead of myself there. Cross examination begins. Mr. Levin says, "Good afternoon." Mr. Slotkin says, "Hi, how are you?" Mr. Mr. Slotkin, do you know how old Erik Menendez was during this December trip to Tahoe? I believe so. And how old? About 19, maybe 20. He couldn't have been 20 because he was arrested at 19. So, and Erik Menendez was not a very good accomplished gambler, I take it. Well, the luck wasn't on his side at that time. There's an at that time. Take a shot. I swear. There's so many of them. All right. So, but did he seem? I think that's a fairer statement. So, did he seem to you like he really knew what he was doing, or just a 19-year-old kid gambling up in Tahoe? I don't know that anybody knows what they're doing. He understood the game. Okay. So now you mentioned before that you said Erik, you believe, would lose and then he would come to you and ask for the money. Is that correct? Yes. And is that what you testified to? Well, it really wasn't a 100% accurate statement. It was kind of during the time he was losing, if he was losing some money, he would ask me if I would loan him some money, and I said yes. Well, I thought I heard you just say that he would come to you for money. That's the same thing in my mind. I'm not drawing the distinction that you are, but ask and I'll try to help you. Okay. This guy's a fun witness. The picture I'm seeking is Eric would come up to you and ask you for money, but you wouldn't necessarily be with him when he lost. You would really be assuming that he lost. That's true. Some of that's true. I did see him lose some money, and some of the money he lost without me being there. And you assumed that he had lost when he wasn't with you. Is that correct? Well, that's why he came up and asked me for more money again. Yes. And when you gave him money, did you give him chips? Well, I might have given him chips, or I might have just put some money down and the house would have given me chips, and I would have given it to Eric. So were you keeping some kind of track or running tab that you were able to remember the money that you gave him? Yes, sir. Okay. I take it this happened because if they're out there gambling on fake IDs, you know they're drinking on fake IDs. I take it this happened at various times throughout. And this happened in Lake Tahoe and in Reno places. Okay. And it happened over a course of time, I take it. 2 days, right. And when Eric Menendez paid you back, did he pay you back by check? I cannot remember really how he paid me back. I think it was check, but I'm not really sure. So do you remember me talking to you out in the hallway a little bit? Yes, you asked me that question and I told you I wasn't sure. And you think it was a check? Well, I can't swear to that. I know he paid me back. Do you remember where you were when he paid you back? No, I don't. Do you remember him giving you something in person? It sounds strange that I wouldn't remember that, but I would remember if he didn't pay me back. Now, do you recall being questioned about this very subject by Detective Leslie Zoller approximately March of 1994? Do you remember the police about how much Eric lost or gambling or what? No, this particular subject matter that we're talking about on March 30th, 1994, do you recall being asked questions about this area by Detective Zoller and Mr. Khan and Ms. Nahara? Oh, hold on. Dog barking. I don't know what she heard, but she heard something. I recall being asked a lot of questions about a lot of areas. Wait, hold on. Let me ask that question again. Do you recall being asked questions about this area by Detective Zoller and Mr. Khan and Ms. Nahara? I recall being asked a lot of questions about a lot of areas, and maybe this was covered. Okay. Do you recall telling you're talking about in the meeting that they had with me, not on the stand, but in the meeting, right? Yes. I don't recall. I just remember there was a lot of ground covered. I'm sure that was some of it. So, do you recall telling Ms. Nahara that Mark said that during the week of Christmas to New Year's of 1989, he, with a few friends, flew up to in Lake Tahoe for a ski trip. Eric went along with them. Eric lost $4,000 to $5,000 gambling, which he had to borrow from Mark to cover the debt. Do you recall that statement? Yes. Well, I don't recall the statement. No. So, yes, but also no at the same time. That makes sense. Yes, no. Yes, well, I don't recall. No. Okay. Some people they give themselves away in their statements, their words. Does the statement I just read to you regarding the amount of money being 4 to 5,000 refresh your memory as to how much it was that you believe you loaned Eric? No, it wasn't any clearer than it was in my previous statements, which I said he lost 5 to 8. I wasn't sure. When do you think you said 5 to 8? Just now. All right. Now, did you not, back in 1994, Tell the district attorney that it was $4,000 to $5,000. I don't recall saying that. If it's in their notes, that would be the best evidence of it. I'm not sure, but I know he lost a substantial amount of money. It was around 5,000. It could have been 8, but it was enough that I would remember it. Could it have been 4,000? I think we would be closer to 8 than 4. Okay. Do you have any idea why you would tell the district attorney 4,000 if in fact it was 8,000? Well, you're saying, did I tell the district attorney? You're saying, did I? And their notes may claim that there was some inconsistencies on other things that, at the pretrial hearing we had to clarify. I'm saying now, for the record, that it was 5 to 8,000. Now, what does that do? He just brought up a pretrial hearing that things needed to be clarified. Does that kind of taint the jury a little bit on something? I don't know what, but does it? Like, kind of suggest something is being hidden from them? I don't know. I'm saying now, for the record, that it was 5 to 8,000, and I don't think I've ever varied from that. But if I did, then that's possible. This this kid. Ms. Abramson says, "May I have a moment, Your Honor?" And Abramson and Levin converse. Mr. Levin comes back. "Do you remember receiving any other check from Eric Menendez?" Ms. Nahara says, "Objection assumes a fact not in evidence that he ever received a check." The court says, "That's what he just asked him." Overruled. The witness says, "I don't remember receiving a check from Eric Menendez. No." Mr. Levin says, "Do you remember ever receiving any checks?" "Well, including the one that he made his payment to me on. I'm not sure that was a check. I don't recall a check that he paid me back." So you just said, "Well, including the one that he made his payment to me on," and now you're like, "Oh no, wait, I just got myself." And now I gotta backtrack and say, wait a minute, I'm not sure if that was a check. I don't recall a check." Mr. Levin says, "Okay, thank you. I have nothing further." The court says redirect, and Miss Nahara says she has some. Ms. Nahara asks, "Mr. Slotkin, in answer to a question by Mr. Levin, you stated that you went to both Lake Tahoe and Reno. Is that correct?" "Reno was a stopover. I can't remember if there was a weather problem or something. My recollections is that we ended up in Reno on the way home. It wasn't part of the vacation. It was just they're somewhat close to each other." "And am I correct that the defendant, Eric Menendez, also gambled in Reno as well as Lake Tahoe?" "While we were waiting for the plane, we all did. Yes." Well, at least you're honest and said you all did. Because it's not like Eric was just like, "I gotta go gamble. I'm craving to gamble." It's like they all went. It was a group thing. And it seems like they went to Tahoe to gamble. Is it not something like Reno also? Like that's where you go to do these things? Do you know? I don't know. I know nothing about gambling, but I'm assuming that that's like the purpose of the trip. Is it not? Do you know if he lost any money in Reno? "I think that's where he lost some money. Yes." "Do you know how much?" "Well, that would be inconclusive in the total. It wasn't in addition to." "Thank you. I have nothing further." The court says, "Anything else?" Mr. Levin says, "No, Your Honor, nothing." The court says, "Okay, thank you, sir. You may step down. You are excused." See, I told you these witnesses are a lot faster today. So, next witness. So, this is Miss Nahara doing the questioning. The people call Wesley Grouse. Sorry. I don't know why I'm struggling with that. That done so bad. So people call Wesley Grouse and he's sworn in and we begin. "Mr. Grouse, I'm going to give you your briefcase because I suspect you're going to need it. The witness says, "Thank you." Direct examination begins. "Now, sir, could you tell the jury what your occupation is?" "Yes, I'm a forensic documents examiner for the LA County Sheriff's Department." So he works for LA County, which is the same uh, county that is putting the brothers away. So just remember that. Or trying to put them away, that did put them away. "And how long have you been a forensic document examiner for the LA County Sheriff's Department?" "For the Sheriff's Department for since July of last year, so almost a year and a half." "And before working for the Sheriff's Department, were you a forensic document examiner for other agencies?" "Yes." "And could you explain to the jury where you have worked in the past as a forensic document examiner?" "Yes. For 8 years. Prior to that, I worked for the District Attorney's Office, LA District Attorney's Office." So that is the District Attorney's Office that is trying to put him away. So if anybody like doesn't see the bias here in these witnesses, now that we're like looking back at this and taking a deep dive into these people that the state is calling as their experts and uh, key witnesses. So he used to work for 8 years for the district attorney's office as a forensic document examiner. And then 2 years prior to that, I was employed with the auditor controller's office here in Los Angeles also. "And could you tell us what your first training experience was to prepare you to be a forensic document examiner?" "Yes. My training began while I was in Washington, D.C., obtaining my Master of Forensic Sciences degree. My coursework my coursework there covered examination of questioned documents or forensic document examination. And the following my formal education there, I took an internship with the United States Secret Service in Washington, also where I worked with 8 different examiners in the Forensic Services Division, where we compared handwriting on threatening letters to the president or on forged treasury checks." This is like what you call a soft science. It's not hard evidence, and it's really subjective and up to the interpreter, the person doing the evaluation. So it's really not concrete evidence of anything. All right, so he continues on saying threatening letters to the president and forged treasury checks. That was the beginning of my training. "And after your training there, did you move on and get trained in another location?" "Yes, and where was that?" "I continued my training when I took a position with the Auditor Controller's office here in Los Angeles, and I worked there for 2 years in with another examiner. And the process of obtaining training in this field is you work in an apprenticeship type of a basis, so someone can evaluate your work and determine if you're properly evaluating the evidence. And then I completed my training when I came to the district attorney's office." So they got their training at the DA's office, or at least some of it. And they're a witness for the DA. So kind of biased, don't you think? "And how did you complete your training?" "I worked with another document examiner there in the district attorney's office for the first year, reviewing to assure that I was qualified in my work, and I also took a course at the FBI National Academy in Quantico, Virginia, which is trained by the FBI document examiners, and also one with Secret Service. The Secret Service has a school in Glencoe, New Jersey, at the Federal Law Enforcement Training Center, so I took that. I also belong to different professional organizations where I continue to obtain my expertise." "Now, sir, in 1992, which one of these agencies were you employed by?" "The LA District Attorney's Office." And in August and September of 1992, were you asked to examine some documents? Yes. And Your Honor, calling the court and counsel's attention to what's been marked as a for identification as 57 and Exhibit 58. Showing you, sir, Exhibit 57, which is actually three documents I'd ask you to look at those documents and tell me if you recognize them. Yes, I do. And is one of them a firearms transaction record? Yes. And are two of them pages 29 and 36 of a federal firearms record? Yes. And have you seen those documents before? Yes, I have. And when did you see them before? Originally, they were submitted to me back in July or August of 92, I believe. And with regards to documents 29 and 36, the pages marked 29 and 36, the signature of Donovan Goudreau, that is highlighted in yellow, as well as on the federal transaction record, the signature of Donovan Goudreau. Did you do some examination of that signature? Yes, I did. And were you given other documents to examine along with this exhibit? Yes. And what other documents were you given to examine along with this exhibit? Ms. Abramson says, objection, Your Honor. The court says you want to rephrase. Ms. Nahara says, I can lead if I may, Your Honor. Were you given a writing sample that purported to be a writing sample from the defendant Lyle Menendez? Yes. And were you also given a writing sample of what was a writing sample of the defendant Erik Menendez? Yes. And were you also given, showing you Exhibit 51, what appears to be some signatures from an individual named Donovan Goudreau? Yes. Now, when you received all of this information, that is, the writing sample of Lyle Menendez, the writing sample of Erik Menendez, and the signatures of Donovan Goudreau, did you do something with them? Just let me clarify one thing on the Donovan Goudreau signatures. I also received some California license applications and license copies as samples of his writing. But then, once I received those, I was asked to make a comparison to see if I could determine if one of those writers was the author of these signatures. And how did you go? Well, first of all, did you do that? Yes, I did make an examination. And how would you describe for the jury what it is that you did? Sure. Examination of documents for forensic examination involves looking at the details of the writing, such as you've probably all done that if you've got a letter from the mother or brother where you recognize someone's writing without even knowing who it's from because there's certain features of that writing you're familiar with that make it stand out and as being that particular person. I do the same thing, but I do it more in depth. I go through a list of different features which I'm looking for, such as the height proportions of letters to his uppercase letters to the lowercase letters, or to see how far below the line that a P or an F might descend below the line, the spacing between individual letters to see how does the writing on the line? I don't know. Okay. Is it above the line? Do the bottom letters not touch the line? Or sometimes the letter will actually go below the line, so the line looks like it intersects the writing. I look for spaces between the different words. I look for how the different letters connect with each other, how the letters are actually constructed, what is the design from that it is used to produce these letters. So, I'm looking at a vast amount of characteristics such as these to arrive to see when what is a person's habit, what are the habits that they have in constructing their letters, because people in general learn to write taught a certain way, and when they develop their writing skill and tend to individualize or develop their own habits from as to how they construct their letters. And that's what makes us able to distinguish one letter from another just in general practice. So I'm looking, this is a really long answer. I can't believe they're letting him continue to go on. So I'm looking at all those features in order to determine from this, is the combination of characteristics so great that I can identify a particular writer and say no other writer could have written these, or some level of certainty along that route, or say that someone didn't write this because of the features that are present there. Okay, now that you've written a novel. Now, in this case, did you compare the various writing samples with the firearms records that you were presented with signatures of Donovan Goodrow and come to some conclusions? Yes. And what are your conclusions? The conclusions I arrived at was that the writing of all these signatures appeared to be consistent with having been one writer, and that writer, there was some evidence to indicate that the writer of the writing attributed to Erik Menendez, that the same writer may have written these signatures. These are some signatures to suggest that he may have written those signatures. He admitted that he's the one that filled out the paperwork and signed Donovan Goodrow's name. So why are we even here with this guy? Like, I don't understand. Erik Menendez testified in the first trial that he's the one that filled out the paperwork. He used Donovan Goodrow's license and all that to fill it out. What are we doing here? Wasting the state's money and taxes on a handwriting expert when we already have Erik saying that he filled it out. It's hard to go through and even remember all the details. However, some of the greater features that stood out in my memory were in the capital D for Donovan. The construction of that letter, from although it had somewhat of a pictorial resemblance to the way that Donovan Goudreau made his D, it actually, the details of that were not consistent with his and very consistent with the writing of Erik, as well as the lowercase e in Erik's writing. He begins the initial stroke of the letter E from near the baseline and brings it up at an angle, and both those letter forms between Erik and Lyle are substantially different and different from Donovan Goudreau's also. So there was evidence in writing that more closely linked it with Erik than with anybody else that was presented. Now, was it possible to make a conclusive, absolute identification? No, it was not. And why is that? The signature had what I call a pictorial resemblance to the true signature of Donovan Goudreau, so it appeared to me that the writer was making some attempt to make it look, in general, like the writing of Donovan Goudreau. And so, in the process of simulating someone else's writing, what you're trying to do is remove your habits or the features that you would normally write, and you're trying to incorporate somebody else's features so it looks like they're writing, and this had that appearance. How do you know that? Okay. And once you do that, the way you identify someone is through their habits, and you're removing your habits. So that gives me less to evaluate. And so that was the process here where I didn't have enough individual characteristics, individual habits to make a positive identification. Of the three samples that you were given, it is your testimony that of the three, the most likely individual was Erik Menendez to have created that signatory. Yes. Thank you. I have nothing further. Court asks if there's any cross examination, and Lyle's team is going to go up first, and Ms. Towery is going to be doing the questioning. Good afternoon. Good afternoon. Excuse me for turning my back to you, but I have my little office set up here. I guess it's Deputy Gross now? Actually, I'm not a deputy, I'm a civilian. So you're a civilian employee of the Sheriff's Department, is that right? Yes. Mr. Gross, you testified at the grand jury proceedings in this case, didn't you? Yes, I did. And you also testified at the prior trial is that right? Yes. And with respect to the handwriting evaluations that you made, you also wrote some reports for the district attorney's office, is that right? Yes, I did. And you have never been able to definitively identify the signatures on the questioned documents as either Erik or Lyle Menendez's signatures, have you? No, I have not. And so you testified before the grand jury and at the last trial, isn't that right? Yes. And you're testifying in the same fashion today, is that right? Yes. So when you're given, in order to make your analysis at the time in 1992, you did have sufficient samples from all three people whose handwriting you were analyzing to make a determination as an expert, didn't you? Yes. And by all three, I mean Erik Menendez, Lyle Menendez, and Donovan Goudreau. Is that right? Yes. I think you mentioned in your direct testimony that you had a driver's license for Donovan Goudreau. Is that right? Actually, I had copies of two licenses that were done two different times, so two certified copies. And you used those documents, those are called known exemplars. Is that right? That's what you can call them known writings or exemplars or standard. They're called different things within the profession. Basically, they're attributed to one particular person as being that writing. So it's the document you have that you believe or are told is writing by that person. Is that right? Yes. And what do you call a document that you don't know who wrote it? We call that the questioned document or the document in question. So the sorry, I was just thinking like that's a very long term. Like wouldn't you just call it the QD? Like there just seems like too many words there. So the document in question or the questioned document, which is kind of difficult to say. So you take your own documents and you compare them to your questioned documents, correct? Yes. And one of your known documents that you had for Donovan Goudreau was a driver's license, correct? Yes. And did you compare the spellings on the questioned document that you were reviewing, which had been marked as Exhibit 58, I guess? Did you compare the spellings of the name of the question documents with the known document? Yes, I did. And was it the same? Is my recollection it was different. That the writing on the document in question was not consistent with the true spelling of Donovan Goudreau. So the spelling was different on the known writing that you had from Donovan Goudreau bearing his name and the document that was questioned. Is that right? That's my recollection. So would it help you to refresh your recollection if you took the known writing out? You do have that with you, don't you? I have photographs of at least some of the known writings, yes. Do you have a photograph of the driver's license that you used or anything else with the name Donovan Goudreau that is known writing that you used to make that comparison? Yes, I do have those. Could you take that out? I imagine it's in your briefcase that you were provided. Is that correct? Yes. Miss Abramson says, "Excuse me, Your Honor." They confer. Ms. Towery says, "May I approach?" The court says, "Yes." And Ms. Abramson says, "May I as well, Your Honor?" The court says, "Yes." Ms. Nahara says, "If I may." Ms. Abramson says, "Could we just have a moment without the witness saying anything to just look, Your Honor?" Ms. Towery says, "That's good enough. I don't want to make you look at everything that you have, Your Honor. Can I mark one of these documents as the exhibit next in order? It's 130 something. I can't remember. 138, the court says. Ms. Towery says, I've marked one of the items, Mr. Gross, that you selected from your materials as Exhibit 138 for identification, and that looks like, I don't know, microfilm, printout, or something of the sort of a part of an application, a driver's license. Is that what you believe it to be? Yes, this would be a photograph of a microfilm copy. All right, and you use the document Exhibit 138 in your comparison as a known sample of Donovan Goodrow's handwriting. Is that correct? That was actually the printing. The signature was actually more of an interest to me off of that application, which is the photograph here. Let me mark that as well. Is this the bottom half of that? Yes. Ms. Towery says, let me mark this as Exhibit 138A, Your Honor. The court says, let's mark it 139. Ms. Towery says, I noticed that the name Goudreau is underlined. Is that your writing or is that the way it came to you? I did not put that writing on there, so that's the way it came. So that's on Exhibit 138, correct? Yes. Now, you testified at the last trial that you could not eliminate Lyle Menendez as a possible writer of the questioned document. Is that right? That's correct. And although you couldn't definitively identify Lyle Menendez as the writer, you also couldn't definitively eliminate him. Is that correct? That's correct. And that's because there were basic, or actually, you couldn't identify him as the writer or the document because there were basic letter formation differences between the question document and the Lyle Menendez known exemplars. Is that correct? Yes, I can explain that further if you'd like, but the direct answer is yes. That's basically, in a nutshell, why you couldn't identify as the writing as Lyle Menendez's writing. Is that right? Yes. And you used some documents as known documents for Lyle Menendez that were provided to you. Is that right? Yes. Who provided the known documents for Lyle Menendez to you? I'm not positive what order they came in or who they came in from. I know Detective Zoller from the Beverly Hills Police Department brought me some of the documents, and it's possible that the two deputy DAs who worked on the case last time also both. I had a lot of interaction with all of them, so I'm not sure in what order the documents came to me. So it's either the Detective Zoller that was the investigating officer on the case, yes, or Ms. Bazanich or Mr. Kuriyama that provided you with all of the known documents that you used. Is that right? That's correct. So all the documents came from either the prosecution or the investigating officer, correct? Yes. So their exemplars were not verified. So we can't even be sure that they're actually their handwriting. And do you have the money documents that you used to make the analysis for Lyle Menendez with you? I'm not sure if I have all of them. I was presented a lot of documents. Well, let me ask you this. Was one of the documents you were provided lengthier than the other documents that you were provided? I believe so. I'm not positive. Like I said, I'd have to look at my report to see all the documents that were provided to me as being attributed to Lyle Menendez, but one was more lengthy. Was it a letter? Yes. A letter from Erik. Excuse me. Ms. Nahira says, Your Honor, I would object to anything beyond anything as to the content of the letter. The court says sustained as to the contents, but why don't we see if he has it here? If he doesn't, it's kind of difficult to refer to it any further at this point. Ms. Towery says, Do you have a copy of the letter that you used as a known document with you today? I have a copy of portions of it. Well, would you take that out, please? Yes. May I approach again, Your Honor? Yes. You can just tell me. I have to ask you questions. Okay. The witness has selected that has selected what appear to be a number of Polaroid photographs from his documents. You took photographs of the actual document itself, is that right? Yes. And why do you do that? It captures more detail than a photocopy, and the particular camera I had takes 1 to 2 photographs. It's the actual size, so it gives me more detail than I would have just from a copy. Well, is it better to did you use the original document to make your comparison, or did you use photographs that you have in your hand today? I used the original. Is it better to use an original? That wasn't his question. Is it better to use an original than photographs or a photocopy in making the analysis? Definitely. What? That's not an answer. And if I showed you the original documents, would you recognize the document you used to make your analysis? Yes. Ms. Towery says, Your Honor, I have a document that I think was previously marked as Grand Jury Exhibit 4A. I'd ask it be marked Exhibit 140. Is it? The court says 140. Ms. Towery says, It's just so I can describe it. It's yellow sheets of paper bearing handwriting. Appears to be 17 pages. Each page is numbered. This was what the whole argument was for, the 17-page document. Each page is numbered in the upper left-hand corner, and the pages are about, I guess, 4 by 6 yellow lined paper, and they're contained within a manila envelope, which is contained within a second manila envelope, which was marked as Exhibit 4A for identification. I'm showing you the documents that I just described. Can you take a look at those and tell me if that was the letter that you referred to that you used to make the handwriting comparison with respect to Lyle Menendez? Yes, it appears to be the same letter. Now, when you made the handwriting comparison, did you use that entire document to make your determination as to whether or not Lyle Menendez was the writer of the questioned document? I used letters from throughout the document. So, whenever you had letters or saw letters in those 27 pages of handwriting that you had, you would compare those letters to the same letters on the question documents and see if they matched. Is that a fair statement? Is that too simple? That's a little bit different than the way I actually did it. Well, then why don't you explain how you do it? Sure. A comparison is made by looking at first, I'm looking at the known writing or the exemplar writing to determine what the habits of the writer are. So, one letter in particular I was looking at was the capital D. So I looked through the letters or to the letter to see if that 17-page letter to see how capital D's are constructed. And so, knowing that that was the letter that was in question, so we don't know that that was Lyle's handwriting, I would go through and determine what the range of variation was. Everybody has a range of variation in their writing. Frequently, people say to me, I don't write the same way every time. I don't sign my name the same way every time. It depends on the document. If I'm signing a check or a will or whatever the situation may be, people do have a variation. And what I'm trying to determine here is what is that range. So it's nice to have an extended writing like this because it gives me a chance to see multiple occurrences of capital D's to see what is the variation in the way that the letter is actually constructed. I'm looking to determine what the habits are, and then I'll make a comparison with the question document to see if the habits exhibited here are often in the question documents. Well, when you do have a lengthy document like that, you don't only use it for one purpose, that is, to compare it to the capital D. You would also use it for purposes to compare it to any other letter in the question documents you are comparing, any part that is in question. And all of the other comparisons you made on direct in order to make your final determination. Is that right? Yes. And so you would use the entirety of a document such as that in making your evaluation. You wouldn't just look at the capital D's and ignore the rest. Is that right? Yeah, if a capital D was all that was in question, that's what I would need to look at. So in this case, you had other letters that were in question. Is that right? Yeah, I'm also looking for, as I mentioned earlier, how letters connect. The connecting strokes, like from the particular situation, the signature was Donovan. So it was a D and then it connected with no O. The question is, how does this particular writing, is there any instance where a capital D goes into the lowercase o to see how those letters are connected, left separate, or actually a connecting stroke that connects the two letters together? I don't know what you did with your Polaroids, but could you just pull those back out for a minute? You didn't use the Polaroids to make your determination. You used the letters you're holding in your hand that's been marked as Exhibit 140. Is that right? Yes. And just again, to describe that letter, it's 17 pages. It begins with Ms. Nahara says, I'd object to any reference to the content of the letter. The court says, I don't see any reason to describe it further. It's right there marked as an exhibit. Ms. Towery says, you didn't mark on the original letter itself, did you? No. When you were making your analysis, did you make any notations about the letter that you were using to make your analysis? No, not in particular. Okay. Ordinarily, if you have a document that is a known exemplar, will you underline the parts that to remind yourself, underline the parts that either support your conclusion or make you determine that it's not a match? Is that something that you would do when you were making your analysis? Normally, I do that, yes. But here he just testified that he didn't make that underline on on the paper. So I don't know if I believe him now. Did you do that on your Polaroids? I didn't do that on the Polaroids. Is that because you can't write on them? No, actually, I can write on them. To tell you the truth, I don't remember what I did in this case. I have limited notations at all relative. I have limited notations at all relative to this case. Going from different offices and stuff, I don't know. So now he's not sure of his notes and he's saying he doesn't have info on this. That's interesting. So is it fair to say that you use the whole document that's been marked as Exhibit 140? You just don't know what particular portions were important to you when you made your determination. Is that right? Other than the particular letters and the way that they were constructed. All right. Thank you. You can just put that back there if you don't mind. Thank you, sir. One last question. You indicated on in your direct testimony that there was some evidence that the writing, the questioned writing, could be attributed to Eric Menendez. Is that right? Yes. However, that opinion is far from conclusive in your own language. Is that correct? Yes. That's what you said in your report. It's far from conclusive. Is that correct? That's correct. That was your opinion in 1992, and it's your opinion today. Is that correct? Yes. Thank you. I have nothing further. The court asks if there is examination and for Eric Menendez. Ms. Abramson says no questions, Your Honor. So they are tag teaming so that it's not as lengthy for the jury. So that's why she was asking some questions for Eric. Like, this is so complicated because she's Lyle's attorney, but yet she's got to make sure that she's asking things for Eric so that Ms. Abramson doesn't have to come up and waste more time in the court to like do, unless she wanted to, she could, but obviously. But if there were only like something she really wanted hammered home, and if they both had things that they wanted done together, like one could do it and then just make sure you get the questions in for the other. And since it was mostly Lyle's testimony, about Lyle's signature, so it was mostly Ms. Towery that had to do it, or someone from his team. All right, and of course, we've got some redirect from Ms. Nahara. And she asks, with regards to the documents that you've brought with you today, Can you show me what Polaroids you used in this analysis with regards? Can you show me the Polaroids that you have of the exemplars of Lyle Menendez that you used? Do you have them present with you? I have the pictures that I took of the evidence. This is one portion of the evidence that happened to use the camera on, to use this camera on. How many Polaroids are there? I believe there's 25 that I have. I don't have the end of the letter here, so I must have misplaced the last portion of the letter, or I ran out of film, one or the two. Your Honor, may I mark this collectively, the 25 Polaroids, as the next exhibit in order? Court says 141. Ms. Abramson says, I'd like to see what they are. Ms. Towery says, I would as well. The witness says, is it possible to just make a copy of them? This is my only record. Ms. Nahara says, I have to. The witness says, okay. There's a brief pause. Ms. Nahara says, now with regard to first, the defendant, Erik Menendez. Ms. Abramson says, excuse me, Your Honor, Erik or Ms. Nahara says, I'm sorry, Lyle Menendez. My apologies, counsel. Ms. Abramson says, accepted. She's cute. I love Mrs. Abramson. She's, or Ms. whatever, Mrs. I know her and her husband adopted a baby during this trial, so I know she's married. Um, I think she just goes by Ms. Anyways, um, she's funny. Like, apologies, accepted. Like, you don't have to even say that, but it's cute. All right, so with regards to the defendant, Lyle Menendez, apart from what has just been marked as 141, do you have anything else with you that you used as an exemplar of the defendant, Lyle Menendez? Okay, just to clarify, you asked it the same way last time. You asked if I used this. I did not use these pictures. These are just to record these pictures. I didn't use these other photographs. The other photographs I didn't use. I took photographs of evidence that I used, and that was presented to me, and I returned all the original evidence. However, I do have photographs of at least the bulk of the writing that I used. I didn't go through for that purpose today to see if I had copies of everything. However, I believe I have the bulk of the writing that was presented to me during the time of my examination. Okay, that was a very long answer, and that wasn't exactly what she asked, and kind of you went in a tangent there. And do you have, so that you can show us, apart from what has been marked as the letter, what else did you use as an exemplar with regards to Lyle Menendez? I'd have to refer to my report to see so I could verify these photographs. If it would help to refresh your memory. Yes, Ms. Chowry says, I would. I'm going to object to identifying the photographs since they're not what he used to make the determination. The court says, you're just referring to these photographs to help you refresh your recollection as to what you used for the purpose of comparison? The witness says, I should clarify something. It might help. I made the initial examination with a lot more documents for Erik's writing or Lyle's writing. Later on, the prosecution asked me to reduce that number. They presented this 17-page letter to be Lyle's writing. Ms. Abramson says, I'm going to object to any further testimony at this point and ask to, based on the conference I just had with counsel, ask to approach, Your Honor. Court says, okay, we can have a little conference at the side. Ms. Abramson says, thank you. The following was held outside the presence of the jury. And so right off the bat, the court's like, what is it you want? Like that just comes off kind of rude, but whatever. Ms. Abramson says, Your Honor, first of all, I think there's some confusion here because the photographs that Mr. Gross was just holding that he had first handed to Ms. Nahara that I then took a look at are all photographs of the 17-page letter. There's nothing else that he handed. Ms. Nahara just told me that now, I guess because I didn't ask any questions, she wants me to make him identify the screenplay. Come on, that's ridiculous. I didn't go into anything. I didn't question the man. We're going to testify. My client signed that thing, so I don't understand the tit for tat thing. Anyways, I object to any questions about what he relied on with respect to Eric Menendez's exemplar. I have hardly challenged him in any way, shape, or form. The court says the entire testimony of this witness is just a function of gamemanship, anyways. Hmm. Ms. Abramson says, not mine. I didn't call him. The court says, that's my appraisal of the testimony of this witness. Key. I just kind of have a question, says Ms. Nahara, Your Honor, I just, I think Your Honor put your finger on it. My understanding is that the 17-page letter is inadmissible as to its contents. I have a feeling, based on what I just observed counsel do, that she is going to make an argument that somehow the letter is now admissible because he used it. The court says, didn't you hear me say that was going to happen before he took the witness stand before you called him? Ms. Nahara says, maybe I just didn't understand. I apologize then, Your Honor. Court says, maybe you didn't hear me say that. You can't understand that's what she was doing from all the conversation that was going on. Ms. Nahara says, right now, from what I observed, I anticipated she was trying to get into the content of the letter. Court says it's quite clear she wants to introduce this letter at the end of trial. There's no doubt about it. That's what her whole examination was designed to do. Ms. Nahara says, right, I don't believe that's appropriate. If they're going to play these, if that's the portion they want to put us in, or if that's the position they want to put us in, quite frankly, I'm getting upset here. If the exemplars are going to come in and that's the way that the foundation is to be laid, fine, we can lay the foundation. The court says, I haven't ruled it will come in. I'm just telling you that was quite clear what the defense intended to do. Ms. Nahara says, then, and the court says, as to why or whether or not that was their intent when they put this witness on their witness list, I don't know, but it was clear during colloquy before he took the witness stand, before you called him, that that's what they intended. Ms. Abramson says, I'd like you to separate the two defenses. The court says, we're talking about the 17-page letter. Ms. Towery says, there's some implication that since I'm the one who did the questioning, it probably was me who did something wrong, and I don't think I've done anything wrong. The court says, I'm not saying you've done anything wrong. Ms. Towery says, I've done exactly what competent counsel would be required to do under the standards of competency and advocacy. Mr. Gessler says, he's not saying you did. Like, chill out, woman. We're not pointing any fingers and saying you did something wrong. The court is saying, I'm not saying you did anything wrong. And then Ms. Towery says, never mind. The court says, I haven't ruled it's admissible. Ms. Nahara says, we are going to lay the foundation in much the same way counsel just did, because we too are competent counsel for the screenplay. Ms. Abramson says, no, you're not going to do that, only if the judge decides you can. Ms. Nahara says, the judge decides that. That's who the discussion is directed at. It is our intention. That's why I wanted to come back here and counsel. We all basically, I think this is very helpful. I intend to, at this game, go into laying the foundation for the 17-page letter. I mean, for the screenplay, and at the end of the trial or at the end of the people's case, we'll listen to argument and the court will determine whether or not both exemplars will be admissible or not. Our position is they weren't, but we're going to cover all of our bases. Court says, okay. Ms. Abramson says, I object, I protest, and I have nothing to do with all of this. The people indicated, and I asked for 402, they were not going to bring out that the exemplar for Eric Menendez was the script. I did not challenge this witness. There's no basis to bring out what the exemplar. The court says, I'll tell you what we'll do. I'll defer ruling on this, and we won't excuse the witness, and we'll hear argument from defense for Lyle Menendez as to how persuasive that argument will be at the appropriate time, and if it's so persuasive that I feel that the exemplars are a critical part, then we can always have him come back if it's necessary. Ms. Abramson says, right. Court says, we'll do it that way, but we won't forget. Okay? Ms. Nahara says, okay. Court says, so make a note that if the defense for Lyle Menendez is offering the 17-page letter on a theory that the exemplars must be seen by the jury in order for the jury to properly evaluate the witness's testimony, then it would open the door to recalling this witness, perhaps to see what else he considered or what else he considered of other exemplars and whether those things equally should be received in evidence. And then counsel for the two defendants can duke it out. Wow. Ms. Abramson says, duke it out, right? Ms. Nahara says, thank you, Your Honor. That will cut down on a lot of what we're doing. The court says, all right, you can file written briefs on the subject. The following was resumed in open court in the presence of the jury, so the jury is back. Before he gets into examination, the court says, all right, anything else? Ms. Nahara says, just briefly, sir, if you can tell us just approximately, oh, wait, no, we are back. And so we're back on the stand. Okay. So Ms. Nahara is now questioning, what's his face again? Mr. Wesley Grose. Court says, all right, anything else? Ms. Nahara says, just briefly, sir, can you tell us just approximately how many documents did you examine that were known documents of the defendant, Lyle Menendez? During which examination? During all the how many were provided to you, I should say. Originally, can I look at my report? Sure. Approximately 20 pages, 20 different sheets of paper that contained writing on them. And with regards to the defendant, Erik Menendez, how many different documents were you provided? Ms. Abramson says, objection, Your Honor. Ms. Nahara says, known documents were you provided? Objection, Your Honor. Irrelevant, and I can swear we just decided this. The court says, we're just asking for a number of pages, not descriptions, just number of pages, nothing else. Ms. Nahara says, thank you, Your Honor. The witness says, would have been close to 50. Ms. Nahara says, and after your examination, am I right in the understanding that you cannot eliminate Lyle Menendez as a person who may have made that signature, but your conclusion is that it's more likely Erik Menendez? Yes. Thank you. I have nothing further. Anything else? Just one question, Your Honor, says Ms. Towery. Ms. Towery says, Mr. Gross, when you said you had 20 different sheets of known exemplars for Lyle Menendez, that's in addition to the 17-page letter that we marked as an exhibit. Yes. Thank you. I have nothing further. Anything else? Nothing. Okay, thank you. You may step down. Take your materials with you. Did you want to keep those photographs, the Polaroids? The witness says I would like to. The court says, as an exhibit, I'm talking to the prosecution. Do you want to keep them here? Ms. Nahara says, based on our discussion, Your Honor, no. The court says, okay, you can take them back, and Exhibit 141 will be vacated as an exhibit number, and we'll use it for something else. Who's the next witness? Ms. Nahara says, if I may have a moment, Your Honor. She wants a moment to look at something. He says yes. Miss Abramson says, I think we need to look at something. I think we all need to look at something, Your Honor. The court says, okay, let's take a recess here. There's something they need to discuss. We'll resume at 25 minutes after the hour. This is like how a normal day should flow. Like it should be boom, boom, boom. Like, well, not should be, but in trials like there should be an ebb and flow and it should be not like say the Karen Reed trial. If you've just watched that, the first trial, there was no flow because Judge Bev interrupted it constantly. And like here there's so many objections to things about evidence that should or should not have come in, or somebody's trying to sneak something in that they shouldn't have, and it's kind of underhanded, but it does like throw the whole flow of the day off. And I feel like we haven't gotten through things because they keep arguing stuff. But today seems like the flow seems to be going better. Anyways, so how now this is the following proceedings held in court outside the presence of the jury. Court says, all right, anything before the next witness testifies. Ms. Nahir says, nothing from the people, Your Honor. The court says, okay, let's get the jury out. Wait, what? Yeah, that was outside the presence of the jury. Something else happened that we missed, or they didn't record. There was something, I don't know. Maybe the lawyers needed to discuss something for a minute. I don't know. All right, so the jury is now back, and they call the next witness. And this is going to be the final witness for this particular stream. So the people call Deputy Michael Guthrie, and he comes up and he gets sworn in and all that good stuff. Direct examination begins. Ms. Nahira says, Sir, what is your occupation? Deputy Sheriff for the County of Los Angeles. So another LA County stooge, LA County, LA County employee we've got. And on June 8th, 1990, were you also a deputy sheriff for the County of Los Angeles? Yes. On June 8th, 1990, where were you assigned? Men's Central Jail. And what were you assigned duties on that date? What were, my gosh, if I could read words or say them. What were your assigned duties on that date? I was a floor prowler on the 3000 floor. Can you explain to the jury what a store prowler is? A floor prowler is what he meant to say. Or she meant to say, yes. And what is that? It's a assist with the operations on the floor, monitoring inmates, and just basic operations of the jail. So he's the floor monitor for the jail. And on June 8th, 1990, were you assigned to search one of the cells that you were monitoring? Yes, I was. And who assigned you to do this? Sergeant Barrett. Were you assigned to do this alone or were you with someone? I was with other deputies. And did you search a cell on June 8th, 1990? Yes, I did. And which cell was that? Module 3100 B12. And who was assigned on June 8th, 1990 to that cell? Joseph Menendez. And the individual do you know who Joseph Menendez was? Yes. And is that individual present in court today? Yes. Would you please identify that individual by where they're sitting and what they're wearing? Sitting at the end of the table with the red plaid shirt on. The court says, identifying the defendant, Lyle Menendez, at counsel table. Ms. Nahir says, thank you, Your Honor. And sir, when you searched defendant Lyle Menendez's cell, who were you with? Deputy Dulla. And what happened? Can you please describe what it was that you did with regards to this search? Court says, this testimony of this witness is offered only as to the defendant, Lyle Menendez, and should be received only in reference to Lyle Menendez. Ms. Abramson says, and any exhibits marked, Your Honor. The court says, and also any exhibits that he refers to or anything that is indicated in this witness's testimony is received only as to Lyle Menendez. Ms. Abramson says, thank you. Ms. Nahir says, thank you, Your Honor. Can you describe to the jury what it was that you did regarding the search to Lyle Menendez's cell? Well, we were instructed to go to his cell. Objection to, objection, Gessler and Towery both objected to that. The court says, just say what you did. The witness says, I went into the cell to conduct a search for contraband. And what did you do? I entered the cell and I went to the left and began searching in the bunk area. And did you find anything in the bunk area of interest to you? Yes, I did. And did you continue your search? Yes, I did. And did you describe what you did? I found objection as to the description of what he found. The court says, do you have something you want to show him? Ms. Nahara says, actually, I believe the question was to describe what he did, not what he found. The court says, how he conducted his search, is that what you're saying? Yes. The court says, just describe generally what you were doing when you were doing your search. The witness says, I go in the cell and I began looking for anything of contraband. And and Ms. Nahara continues her questioning, and when you search, what exactly, what do you do? What do you look at? You look at anything and everything. Basically, they tear the whole place apart. And Your Honor, I have an envelope with 9 pages, a part of which was previously marked Exhibit 255. I would like it marked Exhibit 141 for the record. The court says, all right, 141. Ms. Nahara says, thank you. And I've shown this to the defense. May I approach the witness? The court says, yes. Ms. Nahara says, and showing you what has been marked, Exhibit 141, would you take a look at these documents and let me know when you're through with looking at them? The witness complies and says, I'm done. Deputy Guthrie, do you recognize those 9 pages that I've just had you examine? Yes. And do these 9 pages have writing on them? Yes. And 3 of these pages written on both sides? Yes. And from where do you recognize those documents? These are the items I found. And where did you find them? In cell B12. And would this be in the cell of the defendant Lyle Menendez? Yes. And when you found those documents, what, if anything, did you do? I called to the other deputies to have them examined. Ms. Towery says objection as to anything he said to the other deputies as hearsay, and the court sustained that. Ms. Nahara says, did you get the attention of the other deputies? Yes. And what happened after you got the attention of other deputies? They came to look at what I found. And what happened after? How many other deputies came to the cell? 3. And do you recall the names of those deputies? Yes, I do. And who was that? Dulla, Barrett, and Baker. And was Dulla in the cell with you searching as well? Yes. And what happened after you got their attention to come over? They came over. And did you do anything? I then gave the documents to Deputy Dulla. And did you see what he did with them? He was holding on to them. Did you leave them in Deputy Dulla's custody? Yes, I did. Thank you. I have nothing further. So Mrs. Towery is going to have a couple questions for cross-examination for Deputy Guthrie. She says, Deputy Guthrie, you said were a floor prowler? Yes. And one of your duties as a floor prowler was to do cell searches in the jail. Is that right? That's correct. And those are common at the county jail. Is that correct? Yes. Are you still working at the county jail or are you somewhere else? I'm currently assigned to Lakewood Station. And how long had you been a deputy at the time that you searched Lyle Menendez's cell? Approximately a year and a half. And you said that Deputy Dulla was assisting you in the search. Is that right? Yes. About how big was the cell that you were searching? I don't know exactly. I think they're about 5 by 9. Now, the items that you have identified that have been marked here were not attached by a stapler or some method, were they, when you originally found them? No. And they weren't in some kind of container that you recall, were they? I don't recall. You don't recall where they were in the cell? Is that a fair statement? That's yes. Okay. Aren't you like, shouldn't you know that? And you don't know what order they were in, do you? No. And in addition to the documents that you have identified here in court today, you recovered other papers from the cell as well, didn't you? Yes. And as a matter of fact, kind of a lot of them, didn't you? Yes. A whole bag. Is that correct? Yes. And when you were doing your search, there were papers pretty much all over the place. Is that a fair statement? Yes. So, in addition, there were other items such as books and clothes and food. Is that correct? Yes. So, the papers that are before you in court today also were not folded up in any manner, were they? No. How long did you work in the jail after you conducted this search? Approximately 6 months. And then you were assigned out in the field? Yes. Have you ever gone back to work in the jail again? No. Thank you very much. I have nothing further. Any redirect? No redirect, Your Honor. Thank you. You may step down. Oh, crap. There is another another witness, and that is Deputy Dulla, who I completely missed in my when I went through these notes, or when I went through this transcript. So there is Deputy Dulla is here too. All right, so the people call Joseph Dulla Jr. He's a junior. All right, so he gets sworn in and all this stuff. Now direct examination begins. Ms. Nahara is doing the questioning yet again. Sir, what is your occupation? Deputy Sheriff for the County of Los Angeles. And on June 8th, 1990, were you also a deputy sheriff? Yes, I was. And on that date, were you assigned to custody division at Central Jail? Yes. And on that June 8th, 1990, were you directed to search a cell? Yes, I was. And who directed you to search that cell? Sergeant Barrett. And do you recall whose cell it was that you were to search? Jose Menendez. Like, why were they looking for something specific? Like, did they know this letter existed? I'm confused why they were told to go search this this particular inmate's cell. And the individual, do you know the individual, Jose Menendez? Yes, I do. Is he present in court? Yes, he is. And will you please identify him for the record? He's sitting at defense counsel table in a red shirt. Court says that's the defendant, Joseph Lyle Menendez. Ms. Nahara says, thank you, Your Honor. And sir, when you reached the defendant's cell, did you do it alone or with somebody? With somebody. And who was that? Deputy Guthrie. And at some point in the search, did Deputy Guthrie attract your attention? Yes, he did. And when he attracted your attention, what did you do? I looked in his direction at what he was looking at. And what were you looking at? The People's Exhibit number 8, some pieces of yellow lined paper with writing on them. You said some pieces of yellow lined paper with writing on it. The court says he's referring to the document in front of him. Which was previously marked as Exhibit 8 at the earlier hearing. And Ms. Nahira says, and showing you what has been marked. Court says it's now 1:41. Showing you what has been marked as 1:41, I'd ask you to take a look at those yellow lined papers and tell me if you recognize them. Yes, I do. And from where do you recognize those documents? From the search of that cell that day. And were those the documents that Deputy Guthrie called your attention to? Yes. And after Deputy Guthrie found those documents, were they given to you? Yes, they were. And what did you do with them? I booked them into evidence. I sealed them in an evidence envelope, filled out a label, and took it down to the evidence locker. And showing you what has also been marked as Exhibit 141, that is the envelope that the yellow pages were in. Is that the envelope that you booked them in? Yes, it is. And did you have complete custody and control of them up until the time that they were placed into the evidence locker? From the time Deputy Guthrie handed them to me till the time I placed them in the locker, yes. And the documents before you, are those the documents that you placed into the evidence locker? Yes, they are. Ms. Nahira says, thank you. I have nothing further. Cross-examination. Ms. Towery has a couple of questions. Deputy Dulla, you didn't see Deputy Guthrie recover those documents, did you? No, I did not. And as you look at them today, do they look to be substantially in the same condition as when you saw them, when he showed them to you? Yes. And in addition to those documents, you also booked additional items that were recovered from Lyle Menendez's cell into evidence, didn't you? Yes, I did. A plastic garbage bag full of, Ms. Nahira says, I'm going to object to anything further as irrelevant, Your Honor. The court says, in the same search and the same cell you're talking about? Ms. Towery says, yes. Overruled. Awesome. So you could talk about other things that were found in that search. Ms. Towery says, you booked a big plastic garbage bag full of documents that were recovered from the cell. Is that right? Yes, I did. And in addition to the items that you have identified here in court today, when you were in the cell conducting the search, there were numerous items in the cell. Is that right? Yes. And this is a pretty, I think you described the cell as cramped. Is that a fair description of how big it is? All depends on your definition of cramped. Okay, have you used that term in the past to describe this cell, if you recall? I don't recall. Do you know how big it was approximately? I'd say maybe 9 to 10 feet long by 5 to 6 feet wide. In addition to papers or writings that you recovered from your search in the cell that day, there were also additional items in the cell, such as clothing and food and books. Is that right? Yes. Thank you. I have nothing further. And of course, we've got some redirect examination by Ms. Nahara. Ms. Nahara says, Sir, you testified in response to a question by Ms. Towery that numerous documents were found in the defendant Lyle Menendez's cell. Is that correct? Yes. And a bulk of them, my understanding is, were placed in a large bag. Isn't that correct? Yes. The documents that you have before you, were they separated out from other documents that were placed in the large bag? No, they were booked separately. They were held separate from the very beginning of the search. Well, doesn't that make them more suspicious to me, like as to how they were found and why they were separate? And that doesn't make any sense. Why were all these other documents thrown into a garbage bag, but these particular documents right here, those were separate and booked separately? I don't know. And these documents were always considered separate from the other documents that were found. Is that correct? Ms. Towery says, objection as to who was considering. The court says, sustained. Ms. Nahara says, when Deputy Guthrie found those documents, did he keep them separate and apart from all the other documents that were found? Yes, he did. Ms. Nahara says, thank you. I have nothing further. Um, Anything else? Nothing further from Ms. Towery. The court says, thank you. You may step down. Next witness, Ms. Harris says, Your Honor, that would conclude the people's presentation for today. So they actually did have extra time. They ran out. Man, they're having a hard time scheduling their witnesses and keeping it together in the right order like they had originally planned, and instead of continuously changing gears and reordering their witnesses and whatnot. It's insane. The court says, okay, all right, we'll be in recess until tomorrow morning, ladies and gentlemen. Again, don't talk about the case without anyone. Don't form any final opinions, blah, blah, blah. Don't permit yourselves to be exposed to anything related to this case in any form whatsoever in the news media or the discussions or conversations, and we'll see you back here at 8:30 in the morning. That whole section was new to his little spiel that he always gave to admonish them. Don't permit yourselves to be exposed to anything related to this case in any form whatsoever. Okay, cool. All right, so now the court says, all right, the jury has left the room. All right, court's still in session, and as the court ordered, there are no interviews. Ms. Abramson says, it wasn't an interview, Your Honor. The court says, no conversations. Ms. Abramson says, it wasn't a conversation. The court says, as far as the redacted version of Exhibit 141, do you have such a form here or document here? Ms. Nahara says, yes, Your Honor. The court says, do you want to mark it now so we don't lose track of it? Ms. Nahara says, yes. Would you like me to mark it as 142? The court says, yes. Ms. Nahara says, 142 is the redaction of 141. It has been provided to counsel for the defense for Your Honor, or Your Honor, sorry. Court says, all right, and at some point when exhibits are received or at some other point, there should be some stipulation stated on the record relating to this document, Exhibit 142, so that there won't be any confusion on behalf of the jury, since it's not the same document as 141, which was referred to in the testimony. Ms. Abramson says, Your Honor, why isn't there just a statement in front of the jury? We're going to substitute a copy for the original and be done with it that way. It doesn't tip them off that anything's been changed. The court says, whatever it is, I'm just telling you that it has to be done in some fashion so that they're aware of it because they have seen a different document than the one that will be going to them. Okay, any matters that counsel wish to discuss at this point related to testimony tomorrow or any other issues? Ms. Abramson says, only to let the court know that tomorrow I think we'll have time. I expect that we'll have time for, the bailiff says, can we take the jurors out, sir? The court says yes, and the jury exited the jury room. The court says, you were saying, Ms. Abramson says, yes, I'd like tomorrow to have a 402 motion, Your Honor, on some of the photographs that Roger McCarthy intends to use. I've discussed those first thing this morning with Mr. Khan, but I'll indicate now that I've learned at noon, and I won't know until I go see them myself later this day, that there is a possibility that Dr. McCarthy has changed some of the photographs from the first presentation. Miss Nahara gave me a new disc yesterday, and I think she was of the impression it only contained the new diagrams. He's changed the diagrams. I understand to rescale certain items of furniture, but it's possible he also changed some of the photographs, at least our first view of them. The computer people who are viewing those discs for us seem to think some of the photos may have been changed. I won't know until I go over there, which is where I'm headed from here, to compare the photos on this presentation program with the photos on the previous presentation program which we have. In any event, based on the photos on the previous presentation program, we did have certain objections that more gruesome and less relevant and less demonstrative photographs were being used than what were available from the other photographs, and it's explained to Mr. Khan, or and it's possible, sorry, I skipped a line, and it's possible that to some extent that occurred, as I explained to Mr. Khan, because originally Mr. McCarthy did not have. The court cuts her off and says, let's stop because you're going to be saying the same or similar tomorrow. Ms. Abramson said, I just needed everything and I don't have the photos here to have it today. Court says, tomorrow we have Mr. Eslamania. Is that right? Mr. Khan says, yes, Your Honor. The court says, did you intend to have anything in writing? Ms. Abramson says, it's almost done. Mr. Gessler says, we do, Your Honor. We're on a second draft and we'll have something, but we can't present it to the court until first thing tomorrow morning. But we are working on that at this point. Could you imagine, and I have no sympathy for the prosecutor, but could you imagine being the prosecutor litigating a case and then you've got multiple attorneys for the defense litigating the case and two sides, so both sides can be presenting their own like sets of motions, kind of, you know what I'm saying? Like they can each do their own motions. And so the prosecutor has to now respond to all of those motions. I think, I would just bombard them with motions like Hank Brennan's doing in the Karen Reed case to the defense. Keep her busy with that so she can stop being such a pain with all the witness switching around mumbo jumbo that she's doing. Anyways, Mr. Gessler says they're working on a draft of putting it together first thing tomorrow morning, but we're working on it at this point. Take a shot at this point. The court says, all right, and there is still some brief out of the presence of the jury testimony from Detective Zoller on an issue relating to past recollection recorded. Is that right? Ms. Nahara says, that's correct, Your Honor. That would be involving the witness, Mark Heffernan. The court says, okay, did you want to do that now or tomorrow, or are you ready for that now? Court says, sorry, Ms. Nahara says, fine, Your Honor. Court says, I don't know if everyone has their paperwork. Ms. Towery says, perhaps we can do it tomorrow, Your Honor. Court says, if you don't have the paperwork, it's not. Ms. Amerson says, I cannot tell a lie. I do have the paperwork. I have all the witnesses. Ms. Towery says, I don't. Ms. Amerson says, you don't, but if we can have a few minutes. Which police report was it that you were going to use to refresh? Now the attorneys confer. The court says, Counsel, if you're going to have a debate, we'll take a recess. Ms. Abramson says, we're probably not best trying to reach an agreement on things late in the day when we're all cranky. Does the court recall what the specific claim of we believe the only thing the prosecution didn't elicit from the witness that they wanted to elicit, which he didn't remember, was that when he was the statement that Lyle wanted to get back into the house before the police were done with the investigation. I don't think there was anything else. Ms. Nahara says, that's not. The court says, the question was there some statement as to why he wanted to go back in the house, as I recall? Mr. Gessler says, the dispute comes, Your Honor, to that the people believe that the next line concerning his consultation with Mark Heffernan's wife, he wanted Mark's wife, who works in an attorney's office, to contact a lawyer to get him into the house. I believe that was ruled inadmissible by the court when they first stated that on the relevance grounds. The court says, no, I don't think so. We had a conference out in the hallway. I don't think that's the ruling. If you have some doubt about it, Ms. Abramson says, the witness didn't not remember that. He knew that was true. I thought it wasn't inadmissible. You sustained the objection. The court says, I don't believe that's the way it happened, but if there's some doubt about it, the best thing to do is look at the transcript. At this point, all we're doing is trying to establish if this is past recollection recorded and if there's a dispute as to what the question was and what the issue is when it goes to the jury. Then we can. Ms. Nahara says, Your Honor, if I may. Ms. Abramson then cuts her off and says, rather do something Dangling, I would like to look up. She was in the middle of a freaking paragraph. I would like to look up what the colloquy was in the testimony and focus on that and do it once and do it right and not have to. I frankly can't retain this many dangling little bits this time around. I just can't do it. The court says, I'll be glad to let you look at the transcript. There are various references. One would be the conference at the bench and also the actual questioning of the witness. Ms. Abramson says, right. The court says the question that was asked. Ms. Abramson says, Tuesday's transcript. Court says, and what it was that he didn't remember. And I'd be more than happy to let you do that. We can do it tomorrow and whenever you can do it. Ms. Amerson says, thank you, Judge. For the record, Ms. Nahara says, Your Honor, anything else? Ms. Nahara continues, at the bench, I went up and asked him to read the entire sentence. I then asked him if he remembered that and he said no, I never read this sentence, of course, because we all agreed that a past recollection recorded would be improper to state in front of the jury. So he read the entire sentence, and the next question was, do you recall the conversation? And he did not recall this. The court says, okay, my recollection is that the actual paragraph and what was given to the witness to read was not marked as an exhibit. So whether you marked it on a report or something to identify what it was, I don't know. I have no idea. Or maybe it's identified in the transcript as paragraph such and such of an interview. I don't know how that actually occurred. Ms. Abramson says, but I don't think she had asked every question in the paragraph. We thought that the question that he couldn't remember, the court says, okay, again, look at the transcript and see if we can't pin down exactly what it was. As far as tomorrow, then, as Laminia is the only witness who will actually be available. Is that right? Ms. Nahara says, and Detective Zoller, Your Honor. Okay. And then next week, are there any changes from what we discussed yesterday? Ms. Abramson says, we're going to be objecting, Your Honor, to Roger McCarthy testifying before a foundation's laid for the medical evidence because, just to be fair to the prosecution, because I would object to any medical opinion or any basis for Dr. McCarthy's diagrams or anything else if the record of this trial does not have the medical basis for such opinions, since we know he doesn't have the expertise to form those medical opinions. And I mean, I want counsel to know that. I think in some cases the order of witnesses is mandatory. And since they are choosing to put their pathologist on after this non qualified person, I think there's going to be a problem with what it is that he's relying on. The coroner's testimony will not have been had, the coroner's report will not be in evidence. And so I just want the people to know, as part of my objection tomorrow, the other one is going to have to do with whether or not they will be able to elicit the information they need from Dr. McCarthy in the absence totally of the record of any medical opinion for him. Two, even the fact that they're dead is a medical opinion that he can't render unless their case is dead if a medical opinion if he can't render a medical opinion unless they're relying on something else, and he can't rely on anything else he chooses. It's got to be something that's tested for reliability, admissible in evidence, and before the jury. So that's another argument, and I'm going to do a little research whether there's any case authority to that effect. There is a case authority on the effect that a non-autopsy surgeon coroner can testify in lieu of the actual autopsy surgeon coroner because he's familiar. A, he's got the credentials and the expertise, and B, he's also familiar with the procedures of the office when it's a coroner from the same office, but that's not the situation we have here. The court says, all right, my question is to the prosecution, do you have any changes in your list of witnesses that we discussed yesterday? I have as my list here, you have Kuhn, Stevens, Pisarcik, Anderson, Eisenberg, somebody from a representative regarding home sale in Princeton, in Princeton, New Jersey, a representative of Sun Life Insurance, and Dr. McCarthy, and then Dr. Lawrence the following week. Is that still your schedule? Mr. Khan says, that's our schedule, with the understanding that we indicated that we do want to put on Roger McCarthy as of Tuesday. The other witnesses are somewhat more flexible. We worked it out with Dr. McCarthy's schedule to have him testify on Tuesday. Court says, okay, you heard their objections. It might be fruitful then to focus on the nature of the objections as to whether or not you'll be able to overcome those objections so he won't be able to testify on Tuesday. So if you want to focus on that sometime tomorrow, we would be able to do that. Mr. Khan says, it's my understanding we had a hearing concerning the admissibility of Dr. McCarthy's testimony and the defendants chose to withdraw their objection to his testimony. So it's my position that his testimony is admissible at this point in time. They did not make that objection before, and it's not entirely for them to make that objection now. Ms. Abramson says, well, the people have only just told us within the last 2 or 3 days that they're not calling the coroner and that their only medical witness is coming a week later. That's the problem. As far as specific objections to Dr. McCarthy, we never said we're not going to make specific objections. We withdrew the 801 objection. But with respect to the specific objection, as this court recognizes, we certainly haven't withdrawn it. He cannot formulate medical opinions. Whether he can rely on someone else's in the record is a different issue. But there won't be anything in the record at this point. Take a shot at this point when he testifies, and that's the real problem. And he can't claim that he based his opinions on the opinions of Dr. Lawrence because he formulated his opinions before they knew Dr. Lawrence's name. So that's the problem. It's simply the way in which the people have chosen to select certain witnesses to testify and others not to, and the order of those witnesses. Oh my God, this is going to happen in Karen Reed case, I bet too. I mean, I understand the problem with expert witnesses and their schedule. I've got 7 of them in my wings right now trying to coordinate, but that's not the only compelling interest here. Our position is that Roger McCarthy has no medical credentials whatsoever. He certainly did not formulate any of his opinions on the medical aspect of his own expertise. Even the fact, as I said, that they're dead, he has to rely on someone else to tell them that. And like he can't even rely on the fact that the individuals in the photographs or that he's evaluating are deceased. He needs the coroner to say that. He has to rely on someone else to tell him that. And if they're not going to put that someone else on the witness stand or any other qualified someone else who can verify the procedures that the coroner undertook, then he can't offer those opinions. I agree with her. Mr. Khan says it's our position that the hearing we conducted under 801 would include as part and parcel of that hearing the entirety of Mr. I think he's a Dr. McCarthy's testimony. They chose not to object to the testimony of Dr. McCarthy, period. They did not qualify it at the time of the hearing. They did not say, depending upon which coroner you call or whether or not you call a coroner, only then will we not object to the testimony of Mr. McCarthy. They simply withdrew their objection in toto to the testimony of Mr. McCarthy or doctor. So it's our position at this time that the testimony of Dr. McCarthy is admissible, and we were going to put on Dr. Lawrence this week. We were going to put on Dr. Lawrence today. We were prepared to have him come in today here and testify today. It's again with these witnesses, like we were gonna do this or we were gonna do that, but like everything keeps whatevering, like they just keep changing around their witnesses constantly. It is only because their indication to the court that they were not ready for him that we have been forced to accept this sequence which we did not accept or did not want to accept. This is at their request. This is the result of their objection, since there was no previous objection to Mr. McCarthy's testimony premised upon that it has to be supported by any particular pathologist. I think the court should allow the people to present the testimony of Dr. McCarthy at this time. Take a shot or a drink, a sip, whatever. Take a sip of water. It's just a fun game. The court is familiar with the testimony. The court has heard that testimony, and in the absence of and as a result of the withdrawal of the objection, his testimony should be admissible. Ms. Abramson says, well, Your Honor, first of all, counsel is forgetting a number of things, including the fact that I made it very clear on that Tuesday morning when we ended the hearing that I was not withdrawing objections to Dr. McCarthy's testimony at all. We were just withdrawing under 801 a pretrial objection, number one. Number two, at the time, take a shot, that occurred, there were three county coroners on the prosecution's witness list: Dr. Golden, Dr. Sherry, and Dr. something. I ain't even trying. So it is only 2 days ago that they said they're not calling Dr. Irwin Golden to testify in this case and said they were going to have some custodian of records in response to the court's inquiries from the coroner's office to do something or another with something or another, and we have yet to hear who that person is supposed to be. And the court pointed out that Thursday, when we asked to end the 801 hearing, that the court would expect we would be raising objections to specific aspects of his testimony. Certainly, he can testify that he created those computer diagrams. It's just that, and the court, in fact, even indicated, I imagine there will be objections to medical opinions, etc., etc. And we said, absolutely. And I know Mr. Khan was in the courtroom that day. I recognize him as the fellow who was at the end of the table that day. He can't say we withdrew all objections to that man. I don't know how much clearer we can make it to Mr. Khan that we think Dr. McCarthy is a fraud and is incompetent to testify, and we have no intention of backing off that position. Say it, girl. Say it, man. I love her passion. We just choose to do it in front of the jurors instead of just in front of the court. And somehow this message isn't penetrated that we think this witness is a scandal. He's a scandal in almost every case he shows up in, but he's particularly a scandal in this one. And we intend to demonstrate that to the jury. And we've made it very clear what we feel about it and who the witnesses are we have hired to demolish him, and they chose to go with him rather than the coroner who performed the autopsy. That's the tactical decision. The order of proof is still the order of proof, and we have had many discussions in the past about what an expert can rely on and whether an expert relies on it, it makes that evidence admissible, or whether an expert can rely on something beyond his own area of expertise. And there are cases in this state that talk about the fact that an expert may be familiar with another expert's opinion but cannot express that other expert's opinion as hearsay. And that is particularly true when the expert in question is a medical engineer and the opinions he wants to rely on are those of a forensic pathologist. So they're not even the same thing. So we didn't even know we would be facing this problem until yesterday when we found out who's supposed to testify when, and then there's no coroner in this case. And I didn't create this problem, he did. The court says, again, what I would suggest is that since there's some dispute as to the nature of McCarthy's testimony after the defense abandoned its motion, that you look at the transcript of what was said to identify exactly what it was that we were left with when that motion was abandoned by the defense. Secondarily, it would seem that testimony of a witness such as Dr. McCarthy would, by its nature, since he is not a medical doctor, have to be premised under hypothetical questions that he would be asked to assume certain things, and whether those things are in dispute or not. I don't know because I don't exactly know what the defense testimony is or proposed testimony will be on the subject in dispute, or what Dr. Lawrence would say, because I have no idea. I haven't seen his report, and I don't know what his proposed testimony will be. But it seems to me that Dr. McCarthy has to make certain assumptions in his testimony. And those assumptions are based upon the testimony of others, whether it's Lawrence or someone else. And the issue could very well be whether or not testimony from Lawrence could be, strike that, testimony of McCarthy could be received out of order with a representation made that any assumptions that are presented to him as a basis for a hypothetical question will be proved by the prosecution through the testimony of Lawrence or some other fashion. That's my initial reaction to this controversy. But I would suggest that if there was a particular statement made at the time the defense abandoned its motion objecting to the testimony of McCarthy, that you find it in the transcripts so that we can see exactly what was said. Anyways, that's my initial response to this. And I believe I made this statement once before in regard to Dr. McCarthy that some of this has to be in a hypothetical sense since he is not a medical doctor. He has to, I assume, that there was a dispute as to the certain type of wound, and the certain wound was an entrance wound versus an exit wound, unless he independently has sufficient qualifications to establish that on his own, plus any other issues that are in controversy that you have to assume. Obviously, the preferred way is to have these things litigated ahead of time as far as any factors that the witness is taking into consideration as a basis for a hypothetical question, so that we don't get into a situation of hypothetical question being asked of a witness and underpinnings of that question never being established, which potentially could create great difficulty. So, anyway, those are my initial observations here at this point. That's all I can say. Look at the transcript, and we can have further argument and discussion about this tomorrow. I agree with the defense that this was just recently brought to my attention, and I assume, similar to the defense, that you have decided not to call anybody from the coroner's office except the custodian of records. Mr. Khan says that is correct. That is based upon the report that we received from the coroner's office. But when we had jurors in the box, Ms. Abramson says, wait a minute, the jurors weren't in the box. They talked to Dr. Golden that Wednesday. The court says you're entitled to make any decisions you want as far as which witnesses you want to call and don't call. But if you ask hypothetical questions of a witness, you don't have to you don't have to do so in good faith with an understanding that the underpinnings of those questions will be supported by evidence in the record. Otherwise, the evidence will be stricken, or the jury could receive certain instructions that relate to that witness's testimony if the questions aren't supported by evidence in the record. Ms. Abramson says, I should also indicate, Your Honor, that the report we have from Dr. Lawrence is labeled a preliminary report and it does not cover each and every detail, each and every assumption that Dr. McCarthy made during his testimony at the hearing. So, if the people are going to posit hypotheticals to Dr. McCarthy on the understanding they're going to prove it up later, we want discovery of what is specifically that they think Dr. Lawrence is going to be able to say to support Dr. McCarthy's opinions because right now, although we have some material, I can understand some of the things Dr. Lawrence is saying, some of the things he's saying seem to contradict what Dr. McCarthy testified to. So, we'd want to know who is the medical person who is going to support some of the theories that Dr. McCarthy proposed that are not supported by the coroner and are not supported by Dr. Lawrence. The court says, well, as I understood it, initially here that this is based upon discussions that we had. Why is the court answering this? This should be something that the witness or the prosecution should have to answer to. But he says, all right, so, well, as I understood it, initially here, that this is based upon discussions that we had. There's very limited disagreements between the people's theory as put forward by Dr. McCarthy and as to the analysis of wounds and the nature of the injuries and the testimony of Dr. Cohen, that there was very small isolated disagreements. Mr. Khan says, Dr. Lawrence. The court says, no, Dr. McCarthy. And Ms. Abramson says, Dr. Golden. The court says, maybe I misspoke. There were very small differences between the testimony, the medical testimony that was supporting Dr. McCarthy, and the testimony of Dr. Cogan or whoever it was. Ms. Abramson says, Golden, Your Honor. The court says, different guy. Ms. Abramson says, that's not at all true. There are massive differences. And the court says, I understand from the people that there were very minor differences. Ms. Abramson says, I don't believe that's true. If they're telling you that, I believe they don't understand the evidence. We have a difference between entry and exit wounds. We have a difference between post-mortem and antemortem wounds that are incredibly significant, that are, in fact, the underpinning shot number one alone, which is the underpinning, the core of Roger McCarthy's theory, is that Mr. Menendez received a shot to the left elbow that creased around his chest, went into the side of his right arm, out the back of his right arm, and into the breast of Mrs. Menendez. That is the core of the theory because that accounts for a certain number of wounds that he has to have in order to have his sequence work out. Dr. Golden disagrees on the chest part. Dr. Golden disagrees on the entry wound. Dr. Golden disagrees on the exit wound, and he disagrees on the wound to Mrs. Menendez's breast. Every single component of that, except the fact that Mr. Menendez received a wound to his elbow, that's just number one. Then we have the other two significant disagreements. Mr. McCarthy's theory that the perpetrator went around the back of the couch, leaned over with his shotgun, and tried to kneecap Mr. Menendez when he was already dead by shooting him in the thigh. His whole notion that that's a post-mortem wound is completely in contravention to Dr. Golden, who saw bleeding around the wound path, and he said over and over and over, and not in any amendment, that that's an antemortem wound. That's the second big one where they disagree. The third one where they disagree is the angle of entry on the wounds to her face. Dr. McCarthy draws a diagram that shows this coming from the side. Dr. Golden says it's front and back. They disagree on that. Then there's the last wound to Mrs. Menendez's cheek. Dr. McCarthy says that's the last one and it's an antemortem wound. Dr. Golden said it's peri or postmortem. We're not talking about minor disagreements. So I don't know what Dr. Lawrence was given or who told Dr. Lawrence what was what. One of the things we need, in fact, is a list of what was given to Dr. Lawrence because he was recruited by FAA. FAA is calling all over California trying to find pathologists. They even stumbled on to some of my witnesses by mistake, and eventually Devinder Grewal found Dr. Lawrence in Stockton. And I'm not sure how the information was fed into Dr. Lawrence or what he was given. But as this court knows, we have had Dr. Martin Fackler involved with this case. He agrees with Dr. Golden. Dr. Cyril Wecht agrees with Dr. Golden. Dr. Michael Baden, who is we know his name from many things. He most recently was involved in the Sandra Birchmore re-evaluation of the autopsy. He did a forensic evaluation of Sandra Birchmore in Canton, which is the same investigating officers as Karen Reed. All right, so Dr. Michael Bowden agrees with Dr. Golden. We even had Dr. Boyd, sorry, so many words here. Boyd Stevens, the coroner from San Francisco, he agrees with Dr. Golden. So this is not small differences. This is the mechanical engineer versus the medical profession. That's what this is. And for Mr. Khan to say it's a minor difference, it's the linchpin of Dr. McCarthy's coordinated dance of mafia recreation, and it's completely blown by Dr. Golden and every other pathologist that we have given the material to and said, tell us what you think. So here is like one of the main big differences so far from trial one to trial two. They're not calling their other forensic or they're not calling the ME, they're not calling the coroner to testify to the wounds, but now they're calling some mechanical engineer guy or something. Medical engineer, what is he? I don't know. He's some engineer. He's not in the medical, he's not a doctor like in the medical profession. So there's that. So this is a big difference. And this particular person, Leslie Abramson is claiming that they're going with the whole mafia thing, the mafia recreation. So maybe this is just some paid expert that the prosecution was able to find that was like, yeah, I can make it look like a mafia hit, no problem. And then they just get rid of their own coroner to have this guy testify, who's not even a medical doctor, to testify about a mafia recreation. So here's our like big number one red flag, red flag. This is different than trial one. So just want to point that out here. And it's completely blown by Dr. Golden and every other pathologist that we have given the material to and said, tell us what you think. We're not going to tell you our theory. Tell us what you think. So there's where it stands. Mr. Khan says, once again, we provided counsel with a report of Dr. Lawrence, and Dr. Lawrence indicated that he agrees with failure analysis evaluation of the shooting. Ms. Abramson says some of it. Mr. Khan says those areas in which counsel is referring to, the post-mortem wounds and the antemortem wounds, he agrees with the conclusions of failure analysis. So that report does reflect what counsel is seeking, the medical basis for the testimony of Dr. McCarthy. Ms. Abramson says, well, no, I just want to know. Dr. Lawrence doesn't seem to agree on the chest wounds or how they were caused. He also seems to think a wound that has bleeding along the wound path is antemortem. So there's lots of confusion about what Dr. Lawrence is saying. He says in the report he had to write it in a hurry, and he's obviously concerned about the content. He calls it a preliminary hearing, but I'm interested in what he was given to come up with those decisions. Where did it start? The court says, well, it certainly would help if we had a more definitive report from Dr. Lawrence. That is there that so that if there is a dispute, sorry, let me restart that sentence. Well, it certainly would help if we had a more definitive report from Dr. Lawrence so that if there is a dispute that relates to whether or not he would provide the underpinnings for Dr. McCarthy's testimony, that we can deal with it before McCarthy is called. As I said, it doesn't make sense, would not make sense to have a witness testify to hypothetical questions if you cannot establish the basis for those questions. Mr. Khan says, but once again, I believe that sufficient information has been provided to counsel as detailed in the report that has been given to provide a basis for McCarthy's testimony. Ms. Abramson says, well, I don't. The court says, all right. What I'll do then is just you have the report, you can identify what it is that the defense finds lacking, comparing it to McCarthy's testimony so that we have sufficient opportunity to do so. Litigate it to determine whether or not McCarthy could testify based upon Lawrence's report. Ms. Abramson says, well, his report is a little confusing and vague. He goes into a whole thing about the bodies weren't picked up off the floor and put on the couch. I'm not sure where that's coming from or what that has to do with anything. Court says, I don't want to get into any more specifics, but I really haven't seen it and don't have the resources to compare the report to McCarthy's testimony. That's really what the lawyers are supposed to do. Ms. Abramson says, what we would like to do, the court says, why don't you do that and provide it to me? Ms. Abramson says, before I do that, I would like to talk to Dr. Lawrence. We haven't had a chance to do that. The court says, fine, get on the phone. Ms. Abramson says, we do. We just need to be able to do it during working hours. I don't have his home number unless counsel does. The court says, all right, well, you can certainly leave a message and have him call you back. All right, we'll be in recess until tomorrow, 8:30 a.m. And that is the end of that. So let me know what you guys think, and we will continue. Oh, where is my Menendez brothers thingy my bob? So I gotta add Dulla, Detective or Deputy Dulla for the 25th because or 26th, I missed him. So we went through Lawrence Cohen, Vicky Rivas, Mark Slotkin, Wesley Grose, Deputy Michael Guthrie. Then we had Dula, who I missed, and then we tomorrow or the next stream we will have the actual. This won't be a proffer. This is the actual testimony of Amir Eslaminia, and he is going to go a few days. So that I'm definitely doing that one in parts because he's going to be on the stand for 3 days. So we will get to that in the next stream. So thank you guys so much for joining me. Let me know what you think, and I will see you guys in the next one. Take care. Bye now.